Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Papers.
Minister of Works and Transport.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper in my name. The annual report of the Trinidad and Tobago Civil Aviation Authority for the period 2019-2020, the Civil Aviation number 14 aircraft accident and incident investigation annual regulations 2020. I thank you.
Minister of Public Administration, Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following paper as listed on the order paper in the name of the Minister of Public Administration and Digital Transformation. The annual report of the National Information and Communications Technology Company Limited, IGovTT, for the period 2018 to 2019.
Leader of Government Business.
Madam President, I have the honor to lay on the table the following paper as listed on the order paper in the name of the Minister of Finance. The Value-Added Tax Amendment to Schedule 2, Number 2 Order 2020.
Urgent questions.
Senator Nakid.
To the Minister of Health, in light of recent reports of the repeated postponements of medical appointments at the Eric Williams Medical Science Complex, can the Minister indicate what specific steps are being taken to address the situation?
Of Health.
Thank you very much, Madam President, and a very happy new year to you and all members of this honorable chamber. Madam President, on my insistence, the board of the North Central Regional Health Authority had an emergency meeting yesterday afternoon at 6 p.m., where the entire board met with the executive management team from the CEO go down. We ordered an immediate audit of all outpatient clinic appointments, both medicine and surgical, to determine the magnitude of the problem and the number of patients affected. We are strengthening our telemedicine initiative to assess and triage patients, determining their need and the urgency for care. We have instituted already a pharmacy pickup collection service to be established for stable patients requiring refilling of prescriptions. We are reviewing the appointment system, and we have done an operations review of the clinic management process with a view of improving efficiency, throughput, and patient comfort. And this is a very fine balancing act, while maintaining all COVID protocols, guidelines, and public health measures to ensure safety and to mitigate risks to both patients and staff. Thank you very much, Madam President.
Senator Nakid.
Honourable Minister, the health sector accreditation bill, can you give us a status of the evaluation of that bill as the RHAs are concerned?
Senator Nakid, that question does not arise. Senator Roberts.
Minister, could you alert me to the fact that Why did the meeting only occur yesterday when it appears that there's been a deficit and delayed delivery of medical services for months now?
Minister.
One must realize, without making excuses, we are in the middle of a global pandemic. Health systems around the world have crashed. In California right now, you cannot get an ICU bed. In California right now, you have to wait for a patient to die to get access to the equipment used for that patient. These are not normal times, but that is no excuse. But our parallel healthcare system, both arms have been working fantastically. So this review has been going on for a while, but the recent urgency prompted me to get the board involved and to hold the executive management of the RHA to account. I just want to quote, a Best Western hotel in London is now taking in COVID-19 patients as hospitals run out of beds. Ladies and gentlemen, we are in the middle of a global pandemic, and little Trinidad and Tobago is leading the way. Things are not ideal, we admit, but we are in the middle of a global pandemic and balancing protocols to prevent infections and patient care. Thank you very much, Madam President.
Question, Senator Nakid. Supplementals allowed. Senator.
To the Minister of Tourism, Culture and the Arts, having regard to government's trust to develop tourism as one of its diversification pillars, can the Minister indicate whether the government intends to intervene to avert the impending closure of one of the nation's tourist attractions, the Asa Ride Center?
Minister of Tourism, Culture and the Arts.
Thank you very much, Madam President. It's not often that I get urgent questions. But Asa Ride, like other tourism operators and accommodation providers, has had its revenue model significantly disrupted on account of COVID-19 and as well as the closure of the borders. To its credit, the Asa Ride Trust has kept its workers employed until its recent closure, which I am told is temporary until the borders are reopened and travel resumes. I've had the opportunity to speak with a member of the board who has indicated that of paramount importance is the maintenance and security of the wildlife sanctuary. So they have promised to submit their proposed requirements to me next week.
Senator Nakid.
Honourable Minister, that same board indicated that they had reached out to the government previously and had received no substantial response.
Kid, is there a question in there, please?
Madam President?
No preamble, please. Just ask the question.
Okay. Has the government done anything in light of the fact that the board previously stated it reached out to the government for assistance and nothing was done? What is your answer to that?
Minister.
I have recently spoken to a member of the board, Madam President, as I have stated, just before its closure and subsequent to its closure, and they have promised to get back to me next week with their proposed requirements, and we will sit and we will discuss how we can secure the estate, the premises, as well as maintain the premises.
That's not the question. The question said that the board reached out to them previously and nothing had been done. My answer is why nothing was done before.
Senator Nakid, two things.
Yes.
You can't repeat. Please take your seat. Okay. You can't repeat a question and hope for a different answer. A question was posed and answer was given. You allowed a supplemental and you've now utilized both of your supplemental questions. Next question, Senator Mark.
To the Minister of Health, in light of recent reports that there exists a shortage of drugs for patients suffering from multiple sclerosis, can the Minister indicate how will this situation be rectified?
Minister of Health.
Thank you very much, Madam President. I am so grateful for this opportunity to correct the public record. There is no stock out of any drug in the public health care system to deal with multiple sclerosis. The report in today's papers is inaccurate. That particular drug we got in stocks in mid-December, 600 syringes. More are expected in January. But here's the thing. That particular drug, beta interferon, is an injectable with a 30% efficacy rate. It is no longer recognized as effective treatment for multiple sclerosis. We signed on with new drugs given orally, better compliance, and a 50% efficacy rate in 2019, fingolimod. What is happening? We must question the advocacy, which ignores the medical status of the drug versus the commercial interests of manufacturers. Read in between the lines. We have a better, newer drug given orally versus an older drug given by injection, which has a lower efficacy rate and no longer recognized as effective treatment for multiple sclerosis. I urge all who are advocating for beta interferon to be careful, because the doctors are absolutely appalled by the story. The doctors are appalled and saddened as to how far the commercial interest advocacy has now reached in this country. Thank you very much, Madam President.
Senator Mark.
Madam, I'm going to the next question. Yeah.
Senator Roberts seems to have a supplement.
Oh, you haven't?
Madam President, Mr. Minister, if the drug is so old and so inefficient, why did we order and receive in mid-December 2020 600 syringes of useless drug?
Minister.
Useless? You cannot transition patients from one drug to another at the drop of a hat. You have to manage the progression of the disease, and if they respond to the newer, better drug, then you transition them. So your question as posed shows an acute lack of knowledge as to how drugs work and the clinical protocols that determine how a doctor uses a drug.
Senator Mark.
The Minister of Energy and Energy Industries, can the Minister confirm or deny reports that the bid by Patriotic Energies and Technologies Company Limited to purchase the assets of the Petrotrin refinery and the ParlView Trading Limited has been rejected?
Energy and Energy Industries.
Madam President, the Minister can now confirm that the bid by Patriotic Energy and Technologies Company Limited to purchase the asset of the Petrotrin refinery has been rejected.
Took the government.
Senator, urgent questions has expired.
Questions or notice, questions for oral answer.
Leader of Government Business.
Madam President, as has now become the norm, the government will be answering all questions on notice.
Senator Mark.
Question number 29 to the Prime Minister.
Minister in the Office of the Prime Minister.
Thank you very much, Madam President. Madam President, the Office of the Prime Minister is not aware of any issues related to the acquisition of the Manta Lodge, which require an investigation.
The Chief Secretary of the Tobago House of Assembly has admitted publicly that no feasibility study was conducted by the government or by the THA in the purchase of this particular asset, Madam President?
Minister.
Madam President, I am not so aware, but even if that is so, and that what Senator Mark has stated is a fact, it does not require an investigation into the acquisition of the Manta Lodge.
Kate, whilst this asset was purchased in 2015, now we are in 2021, no attempts have been made to refurbish or to get that particular asset up and running. Can the Minister clarify that for this Honourable Senate?
Senator Mark, I won't allow that question.
Can the Minister indicate who was the Secretary of Tourism when this particular decision was taken?
Senator Mark, that question does not arise.
Indicate whether Tracy Celestin was in fact the Secretary of Tourism when the decision was taken to purchase this particular asset?
Senator Mark, that question also does not arise. Next question. Next question.
Is it the acting Prime Minister? No, they don't know. I said the Prime Minister. Sorry.
You of all persons are well versed and should be well versed in the parliamentary proceedings. Minister in the office of the Prime Minister.
Thank you very much, Madam President. Madam President, there's no fixed contractual arrangement with any company for the disposal of election documents or any paper waste of the Election and Boundaries Commission. Instead, as and when necessary, New Age Recycling, formerly ACE Recycling, is contacted to collect the shredded waste of the Commission and dispose of same at no cost. In this case, due to an oversight, some of the documents provided had not been correctly shredded before collection. As soon as the Commission, that is the Election and Boundaries Commission, became aware of the issue, they contacted the company to ensure that all remaining documents in their possession were satisfactorily destroyed.
Madam President, can the Minister indicate to the Senate whether this process that he has described has been in existence for how many years? What period of time this process has been in existence, where companies have been selected randomly? How long?
Minister.
Madam President, there was absolutely no indication on my part, and it is completely rejected that companies are being selected randomly. The Election and Boundaries Commission, whether they like it or not, is an independent body, and they, as stated in this answer, contact a company, New Age Recycling, formerly ACE Recycling, to collect shredded waste, indicating that they do their own shredding and that ACE is the one who collects it and disposes of it at no cost.
Madam President, is the Minister aware that Grand Bay, located in O'Meara, was the company where all these ballots or some ballot papers were found on their premises? Is the Minister aware of this?
Senator Mark, that question doesn't arise.
Can the Minister indicate whether this independent EBC is governed by established procurement procedures in selecting companies to dispose of ballot papers when they are no longer in use, Madam President?
Yes.
And can the Minister provide us with answers as to the process involved in the selection of Grand Bay, the company that got $5 million from this government for that particular exercise?
Senator Mark, that question is not allowed. Next question, Senator Mark.
Thank you, Madam President. May I put this question to the Honorable Minister who is grumbling at the side? I want him on the mic. I want him at the mic. Don't grumble.
Senator Mark, and there should be no grumbling at all, okay? Minister of Finance.
In July of 2018, Cabinet agreed to the acquisition from Australia of 2 fast ferry catamarans to service the inter-island sea bridge and 2 patrol vessels for the Trinidad and Tobago Defense Force, the Coast Guard, to patrol the offshore areas of Trinidad and Tobago as follows. 1 INCAT 100-meter fast ferry vessel, 1 Ostal 94-meter fast ferry vessel, 2 Ostal Naval Cape-class patrol boats, Cabinet also agreed that the government of Trinidad and Tobago pursue financing arrangements for the vessels through the Export Finance and Insurance Corporation of Australia, also known as EFIC. Terms and conditions set out in the credit agreements with EFIC for the financing of the acquisition of the vessels are as follows. The tenure of the financing facilities, 12 years. Interest basis, 6 months LIBOR plus a fixed margin of 2.1%. The current effective interest rate is 2.34%, and the repayment structure is 24 consecutive semi-annual repayment installments. With respect to Part 2, subject to the approval of Cabinet, the credit agreements can be laid in Parliament.
Senator Mark, before you ask the supplemental question, can you, for the record, just say what the number of the question that you have posed to the Minister? You didn't indicate.
I posed question number 31 to the Honourable Minister of Finance.
And now you can ask the supplemental. Thank
Madam
you.
President, can the Honourable Minister of Finance share with the Senate what was the actual amounts borrowed by the government of Trinidad and Tobago through EFIC for the 2 fast ferries as well as the 2 patrol vessels?
Minister.
Madam President, the cost of the patrol boats is a total of US $91.5 million, and the cost of the fast ferries, the Incat ferry cost $72.977 million US dollars, and the Ostal ferry cost $71.48 million US dollars. The credit agreement covers 80% of the total funding.
Could the Honourable Minister indicate whether the credit agreement, which was recently laid in this Honourable House, would have provided us with a clear appreciation of what this 80% amounts to for the boat vessels?
Talking about
Is the Minister aware that credit agreements involving both the loan via EFIC for the purchase of the ferries were in fact tabled in this Parliament? Is the Minister aware of this?
no idea what you're talking about.
Madam President, can the Minister indicate whether the entire $91 million US for the 2 fast patrol vessels were in fact loaned to Trinidad and Tobago by EFIC?
Madam President, I thought I said that the cost of the 2 patrol boats was a total of $91.5 million US, and the ferries cost $72.977, I believe, for the Incat ferry, and $71.48 US million for the Ostal ferry, and the credit agreements cover 80% of the total funding. I thought I said that.
Senator Mark, your questions, you've asked all. Next question, Senator Richards.
President, good afternoon, colleagues. Question number 56 to the Minister of Social Development and Family Services.
Social Development and Family Services.
Thank you, Madam President. The Integrated Social Enterprise Management System, known as ISEMS, is an enterprise resource planning solution that facilitates electronic case management of clients of the ministry and the wider social sector, as well as provides a single-door approach to accessing social services. The solution will provide seamless, interoperable, and integration, and will enable data and information sharing across the organization and other government ministries and service providers. At present, iGovTT, acting on behalf of the Ministry of Social Development and Family Services, has successfully procured and entered into a contractual agreement with Fujitsu for the implementation of ISEMS. The project commenced in October 2020. The ministry has envisaged that the expected time frame for completion for the digitalization of all grants and programs through the Integrated Social Enterprise Management System is the end of fiscal 2021.
Senate. Next question,
Yes.
Senator Richards.
Thank you, Madam President. Thank you, Minister, for the answer. Question number 61 to the Minister of Tourism, Culture and the Arts.
Minister of Tourism, Culture and the Arts.
Thank you very much, Honorable Senator. The advent of the COVID-19 pandemic has reduced the artist's ability to perform in the conventional way. This has resulted in the need to reassess and rethink processes for the growth and development of the culture sector in this challenging environment. The Ministry of Tourism, Culture and the Arts encourages musicians, artists to host virtual performances and create virtual events which utilize digital platforms under COVID-19 protocols. These platforms provide artists and creatives with the opportunity to export cultural assets to a global audience and can be monetized. In light of the above, and with respect to part one of the question, the Ministry of Tourism, Culture and the Arts has implemented a number of measures to assist musicians, artists. These include a 50% reduction in the rental cost of performance spaces at the National Academy of the Performing Arts, SAPA, Naparima Bowl, and Queen's Hall. This initiative will provide artists with the opportunity to use facilities for the production of virtual performances at reduced costs. To date, 37 artists and organizations have benefited from this initiative since its implementation in July 2020. The National Registry of Artists and Cultural Workers provides benefits to artists and cultural workers through incentives granted to companies. Companies sponsoring artists' productions receive a tax incentive of 100% for philanthropy and investment in the arts up to a ceiling of $1 million under the Corporate Tax Act. This will facilitate corporate sponsorship of nationals in the local fashion industry, audio, visual, or video productions for the purpose of local entertainment and local production companies in respect of their own productions, as well as for companies which sponsor art and culture. The National Days and Festivals Fund supports projects and events that facilitate commemorations and celebrations at a national level and in communities that preserve and promote the cultural traditions and values associated with our national days and festivals. The Culture and Creative Arts Fund supports requests by cultural organizations which promote the development and sustainability of Trinidad and Tobago's culture, art forms, and expressions. Since the advent of the COVID-19 pandemic, several of the requests received under both funds have been for virtual events. The Ministry continues to consider and support requests which are innovative and developmental in nature. Due to the restrictions on public gatherings, celebrations are curtailed for numerous cultural events. In response, the Ministry provided sponsorship to cultural events such as the Diwali Utsav virtual concert, the Soca in White virtual concert, and the Sans Humanity Extempo virtual showdown. These events have reached a large audience, with the Diwali Utsav reaching 20 million views. As part of these sponsorships, the Ministry ensures that there is a return on investment through brand logo placement, streaming of destination videos, and on-air mentions of sponsorship and support. With respect to part two of the question, the Ministry of Tourism, Culture and the Arts has utilized traditional and social media platforms to create awareness among artists and creatives on several of the initiatives identified. The managers of performance spaces under the purview of the Ministry of Tourism and Culture and the Arts have indicated that several artists and cultural organizations have collaborated to produce virtual performances, inclusive of virtual concerts, plays and shows, as well as recording of same at the facilities.
In light of the Minister's answer, can the Minister indicate if creatives involved and who depend on Carnival for their income and have been significantly impacted have been facilitated by the Ministry in streaming the content on the Ministry's website?
Minister.
not on the ministry's website, but they utilize their own virtual platforms. We have collaborated on their behalf with TTT as well to stream via the TTT online platform.
Senator Richards?
Is the ministry willing to provide that sort of facilitation through the Ministry of Tourism's newly launched website to artists who wish to access that?
Minister?
The Facebook page, yes, we are willing to do that.
Next question, Senator Richards.
Thank you, Madam President. Question number 62 to the Minister of Tourism, Culture and the Arts.
Minister of Tourism, Culture and the Arts.
Thank you very much, Madam President. The Trinidad and Tobago Music Company Limited, Music TT, is mandated to stimulate and facilitate the business development and export activity of the music industry in Trinidad and Tobago. Music TT also provides industry-wide strategic direction and plans for the development of the music industry, guidance and access to music education and capacity development, especially in the business and monetization of local music and protection. With respect to the digital music purchase streaming framework in Trinidad and Tobago, Music TT has indicated its support for the strengthening of the enabling environment for recording artists. This is inclusive of digital music streaming downloads and subscriptions. Music TT has advised that it has commenced the implementation of initiatives aimed at strengthening the enabling environment as follows. Education and awareness campaign for the Trinidad and Tobago International Standard Recording Code. This campaign seeks to simplify the management of rights when recordings are used across different formats, distribution channels, or products. Music TT has advised that the Copyright Organization of Trinidad and Tobago has been identified as the national distributing agency for the International Standard Recording Codes. This will assist in identifying music that originated from Trinidad and Tobago for digital purchase, streaming, and distribution. Hosting of the Reverb webinar series. Reverb is Music TT's first ever webinar series on the business of music. These webinars educate artists on music distribution and leveraging intellectual property and metadata for revenue gain. Further to the above activities, the Intellectual Property Office has advised that several major music streaming platforms are available locally to artists for the commercialization of content, including Amazon Prime Music, iTunes, Deezer, and YouTube. It should be noted that these are based on IP licensing and is private sector driven by market forces. To date, Spotify is not yet available in Trinidad and Tobago. Music TT has advised that there is no legal impediment. However, Trinidad and Tobago's market is not large enough to be considered for entrance by Spotify. Consideration is being given for the Caribbean region to approach Spotify as a single market to lobby for the introduction of the streaming platform. In respect to part 2 of the question, Music TT has advised that where gaps exist or there is need for legislation to correct shortcomings, the company will work with the Ministry of the Attorney General and Legal Affairs and its ministry, Ministry of Trade, to bring the legislation before the Parliament.
Senator Richards.
President, I don't know if the Minister can answer the question because I know, if I'm not mistaken, Music TT falls under the Ministry of Trade. But can the Minister indicate if Music TT has done an assessment of the impact of the government-stated cancellation of Carnival on the local creatives who depend on Carnival as a launchpad for their products?
Minister.
It is under the Ministry of Trade. I can't answer that at this time.
Senator Richards.
Finally, Madam President, can the Minister indicate if, in light of his answer to the penultimate question, if the Ministry of Tourism, Culture and the Arts is considering creating its own platform like Spotify instead of depending on an international platform for our local artisans?
Sir.
Be to duplicate what Music TT does. Music TT is specifically charged with the monetization of the music, local music. So no, we are not considering that at this time.
Public Business, Government Business Bills, second reading.
Honourable members, the debate on the second reading of the following bill, which was in progress when the Senate adjourned on Tuesday, January the 12th, 2021, will be resumed. A bill entitled An Act to Amend the Evidence Act, Chapter 702. There were 9 speakers already who spoke on the 12th of January, including the mover of the motion, the Attorney General. Senator John.
Madam President, thank you for the opportunity to join the debate. Madam President, Senator Vieira, at the beginning of his contribution on this very bill, quoted Baron Tom Bingham, who said the right to a fair trial is a cardinal requirement of the rule of law. First, it must be recognized that fairness means both sides, not just one. And a trial is not fair if the procedural dice are loaded in favor of one side or the other. The Honourable Senator did pose a question. He said, are we loading the procedural dice in favor of one side or the other? Madam President, the Senate plays a role in ensuring that this dice is not loaded, an important role of one side or the other. Because in our jurisdiction, the majority of persons who are before the criminal justice system are not the rich, they are not the privileged, it is the poor, sometimes illiterate and underprivileged. It is the common man who cannot afford attorneys. It is those who are negatively labeled as stereotyped because of the areas in which they live. Indeed, the people who will never get a seat on that iguana tail. Those are the persons in the majority who are going to be affected by this bill, Madam President. I made this point to make another one because it appears as if our government is not interested in treating with the mitigating factors which deter from crime. Because just last week, the Honourable Minister of National Security was in this very house responding to a question. And he was speaking on a committee called the Community Recovery Committee. And he said the committee held consultations in several areas, including Beverly Hills, Sea Lodge, Second Caledonia, etc. And he said they identified, based on their consultations, that there was the issue of employability, of jobs, education, and infrastructure. The minister is claiming that he needed a consultation to find that out, that people needing jobs in particular areas, as a mitigating factor against crime. So, Madam, we ask, is the dice loaded? So in looking at the various clauses in the bill, in examining the various clauses, I look at Clause 12A as the first one. There is an attempt, of course, to bring structure, cohesion, to basically standardize the manner in which evidence is identified, recorded, stored, presented. And that is not a bad thing on the face of it, if we are to ensure this dice is not loaded. The Honourable Senator Lachmidial spoke about the difficulties encountered with lack of paper. Senator Renuka Rambajan spoke of black and white photographs and photographs printed on photocopied paper. And I can tell you 2 weeks ago, I was called by a police officer asking if I had any almanac and diaries for 2021. I'm still trying to pick up a few from little stores as I go along. And that's not a hyperbole. It is the truth. Yet in this amended bill, it places a heavy reliance on audio and videotaping when they don't have paper. So the fundamentals in terms of implementing whatever is being proposed in this amended bill, the fundamentals are not right. Because the government cannot provide paper for the police stations as at now. How are they expected to implement videography in law as a part of the requirements of this bill? I mean, yes, our Honourable Senator Vera went on and said these are matters that need to be addressed. But it is no need, it doesn't mean that we have to criticize, to hold back or challenge this legislation. But again, we have to answer the question as to whether the dice is loaded. Because it means if we can't have these basic things and the fundamentals are not right, then how is one going to move forward? And I'm hoping the Honorable Attorney General will talk about whether there will be a period, if this bill is passed, whether there will be a period of training, and ensuring that the officers who have to, or the practitioners, will be able to get the required level of training to ensure that people are not denied their rights. Madam President, Clause 12A of the bill, in the first description, and this talks about the first report of the description of the suspect who has committed this act. And what I'm seeing here, they have put in law where this form that has to be filled out, and there's, again, a heavy reliance on the procedure, and that, I said, that is not a bad thing, but will it be done? But in addition to that, they have the distance the eyewitness was from the suspect, and I'm being told, because, Madam President, I'm not an attorney at law, but I'm a lawyer by Google.com, and I think that is sufficient sometimes. The distance the eyewitness was from the suspect, the weather conditions. A witness who is flustered, who had just witnessed a crime, is it that they can take in all of that, the distance from the eyewitness? Maybe this is done now, but certainly I think that the priority should be on the person, the personal features, whether the description of the person, because that may be what they may have immediately in their head, which can help the police officer in solving or moving along with his solving the crime. So, Madam President, what I'm saying is, given the nature of the first description, it will be impractical to expect officers to get a first description from a witness as they see to include 1 to 7, as is placed in the bill, and which makes no mention of the physical descriptive factors such as complexion, hair height, built, and distinguishing features, if any. So this should be placed on the form to be noted, because all I saw at the back attached is the form with the JP's form. I don't know, I can't recall seeing it even in the draft regulations, whether they have such a form that is in the purview of the Commissioner of Police. So having all of these things, I think Senator Welch also made the point, creates an undue burden, an impractical and unnecessary burden on the police. Madam President, the use of photograph, that is in 12B, where it says, just now, let me try and find 12B. Prior to the conduct of an identification procedure, an investigating officer may use photograph to assist in establishing the identity of the suspect. The suspect has no right to object to this procedure being used, nor to the photograph being shown. There is no indication of the source of the photographs and what happens to the suspect photograph if he is not identified. Should the photograph of the person not identified be destroyed? Again, the legislation is silent on this. And in section 12B7 of the bill, it refers to the Commissioner of Police having the responsibility of keeping the photograph used in the lineup. I mean, again, that is putting a big burden and a lot of paper on this Commissioner of Police. Is it that maybe somewhere in the station, it cannot be kept for ease of retrieve after? Because if the AG, the Honorable Attorney General, that is, wants to create a proper process, then create a proper process that really takes into account the practicability of the enforcement and the implementation of this process. Madam President, in clause 12B8, photographs shall not be used to establish the identity of a suspect who is in custody. And I've been told that this bill sort of takes some of its own, it reflects what is done in this PACE UK 1984 bill, and basically it says the photograph shall not be used to establish the identity. This should be compared with PACE UK Code D, paragraph 3.3 in my reading, which states that a witness must not be shown photographs, computerized or artist composite likeness or similar likeness or picture if the identity of the suspect is known to the police and the suspect is available to take part in a video identification. It should be noted that photos being shown to a witness may encourage the witness to think it must be one of those persons, because they're thinking, if this photograph is shown, maybe that person is there in the line. Maybe that is my guy, and I probably ought to identify him. And I think in ensuring that people's right to a fair trial is not compromised, we have to look at these things. Now, Madam President, Clause 12F, rights, consent, and cautions. There continues to be reference to everything being noted in an approved form. Now, this needs to go in conjunction with the station diary, because without this, we run the risk of police saying that the suspect refused all identification procedure. Because when I looked at the comments from the judiciary, they made the point that many times, maybe I didn't work with it up here, when this is asked, the report on what is entered in the station diary is, when it is requested in the court, many times the police does not have it, and they are wondering whether they don't have it or they never had it, or whether it's a direct ploy because they don't want to account. Madam President, and the comments from the judiciary went on to claim that because sometimes these matters are being heard 10 years after. So if it is, and this was taken straight out of what the judiciary submitted to this bill, if it is that a matter is taken 10 years, wouldn't it have served our purpose better to treat with the length of time cases take from the moment they are initiated to when they get to when they are resolved, that is? Because having justice and having that the dice is not loaded one way or the other also means justice must be on time. So we are here talking about moving forward and embracing the technology, which it's all well and good. But if people are waiting, and when the judiciary said 10 years, they're putting the best face on it, you are talking about 20 years and 25 years that people are waiting on their justice. And I think we should have, the government should be working on really, is this bottlenecking that you have where people have to be sitting wherever in these cramped facilities and waiting on justice whenever it comes. I think the resources, because the police budget was cut by maybe 30% or more in the last period of budgeting. And whatever money that is allocated really should be spent in fixing the system. So asking the police to do more without the resources really is a case in futility. I cannot see it. I mean, I wish the Attorney General well, but I can't see if it is in a paper-based system. Things are not working well now, how it's going to be working better with what we have been asked to approve here. Madam President, moving over to Clause 12Y of the bill, I'm kind of skipping a few, where they are asking, in Clause 12Y, it says, 1, a video or audio recording of the whole or part of a witness statement shall be admissible as evidence, where video audio recording is admitted as evidence pursuant to subsection 1, etc., etc. And in section 4, that's 12Y, where direct oral testimony referred to under subsection 3 is given, the witness shall not be asked to address any issue. I believe that this disqualifies this Evidence Amendment Act immediately. And really and truly, this needs a special majority. Because I cannot understand how one can just ask a witness to give evidence in whatever circumstances and then say that where direct oral testimony refers to under subsection 3 is given, the witness shall not be asked to address any issue in examination in chief, cross-examination, or re-examination that is in the estimation of the court has already been adequately addressed in a recording under subsection 1. Madam President, prior to coming here, I saw where Senator Welch had submitted his amendments, and he actually recommended that this clause be struck out, be just eliminated. And I think that is very good advice, quite frankly. Because if it is you are relying, I suppose when, let me backtrack, when our Senator Lodge saw this, that is what she thought was ad hominem, which was disproved by Senator Segram Singh Sukla. But it appears as if, and the Attorney General in the Hansard, I looked at it again, speaking about complex matters before the court, as if the dice is loaded. You get the impression that the government is legislating in the way I did maths in school, where I will look in the back of the textbook and see the answer, and then I work it out. I wasn't good at maths as our goodly Senator Lodge. She's an island scholar and got a 1 in maths. I had to look for the answer. and then I will work to suit. So I get the sense that this is what is being done here, because I cannot understand that it's still the case that, it is still the case, of course, that you are innocent until you are proven guilty, and you have a right to a fair trial. So if it is the Attorney General wants this to be law in Trinidad and Tobago, I believe strongly that this particular clause needs a special majority, because this is really infringing the rights of people, that somebody can go and sit down and be a witness somewhere in some rarefied environment, and then this is just placed and projected in a court of law that is just and fair. And a decision is made about somebody's liberty or lack of liberty on the basis of that. You see, you can't, it has no alternative facts, I suppose, in law.
Senator John, you have 5 more minutes.
Thank you, Madam President. As Senator Sagram Singh Suklal had made the point, she said, she will be in a conference with clients, and then they'll be good and talking, they're okay, but some senior counsel will come and mash them up. That's her words, mash them up. But that is what cross-examination is about, because you have to probe, and that is why one has to go to the court and face the accuser, because who alleges must prove. And if it is that, as is being done, Madam President, on some political platform, all kind of allegation and so on, and this government decides who is innocent and who is guilty, I want to refer them to a very famous case in the state of California versus O.J. Simpson, where a very famous attorney said, if the glove don't fit, you have to acquit. It's as simple as that. You can't make up facts. You can't have alternative facts. And if it ain't working out, you'll decide that you'll put a man on a videotape who you cannot cross-examine for whatever reason. I'm not sure that I saw it, why he cannot be cross-examined. Maybe if we go on to, there's another section where you talk about special measures and so on for vulnerable people, and one could understand some bit of that, of vulnerable people having, you can take they can be a witness via video link, etc. But if nothing is wrong with this person, and let's suppose, as was listed in the judiciary's response, they take 10 years or 20 years, and this witness unfortunately dies. What happens then? You are there with this videotape, and he is there safe in the arms of Jesus, and it's you to catch. So I don't understand that, Madam President, and I don't think this is something that we can agree with. And I don't know if I have any time. There is another, I think it's 12AI, where the minister, meaning the minister, I think, of National Security, in consultation with the Director of Public Prosecution and the Commissioner of Police, may make regulations. Madam President, I don't know where the government is going with this. It means we come here, and if this bill is passed, then what happens? The Honorable Minister of National Security, etc., goes off, and they make their regulations, and which never comes back to this Parliament. And we see what is happening with the public health ordinance, where every Monday morning you see a new thing coming out. Or even here, when we came to debate the amendments, the following morning they had to change, the government had to change it again, because one did not bring the regulations with the legislation. So I'm urging the government, should this piece of legislation be passed, that they bring the regulations to the Parliament for the scrutiny of Parliament. Because justice, we have to be sure that this deck is not stacked one way or the other. So, Madam President, sometimes change is slow. I agree, sometimes too slow, based on what maybe the government wants. But in this week of the celebration of the Honorable Martin Luther King, who said, the arc of the moral universe is long, but it bends towards justice. It means real justice. It's not a stacked deck where you believe that you can put somebody a videotape in Hollywood production and come and persecute a citizen of this country. Madam President, it is wrong, and the opposition cannot and will not agree with that. Madam President, I thank you for the opportunity.
Senator Dylan Remy.
Thank you, Madam President. As this is my first presentation in the House for this year, 2021, I bring New Year greetings to all my colleagues in the Senate and to you, Madam President, and to the entire nation of Trinidad and Tobago. It is a new year, and I anticipate that it will be a difficult year, but I trust that we will all make every effort to do our best in this August chamber. Madam President, thank you for allowing me to contribute to this Evidence Amendment Bill 2020. I first want to commend the legislators for embarking on this journey to a more technological approach of collecting evidence. This is a timely move given the changing times and, given the changing times and would require updated and more effective procedures. Madam President, my contribution today will be brief and crafted on two overriding concerns. The first would be the effect that the bill would have on the wider population, and it's in keeping with some of the contributions that have already been made. And the second is the availability of resources within the arm of the police service to carry out the changes that are going to be required as a result of this bill. I was incredibly pleased to see that so many stakeholders passionately contributed to the development of the document here. The Attorney General would have mentioned in the Joint Select Committee the number of the Special Select Committee, the number of persons that were involved in the discussions, and I did listen to some of them. The piece of legislation would result in significant change in the way all lawmakers operate. I implore the Attorney General that we continue to look carefully during the committee stage at the recommendations submitted on this bill to make sure that any ambiguity or loopholes or unfairness is avoided in the processes that are going to be put in place. It is my understanding, based on the research conducted and from listening to the stakeholders, that some of the amendments are consistent with the common law principles and general practice and procedure. In that regard, the amendments will create an even more uniform and standard approach. Nevertheless, as I said before, there may be areas for change, and as Senator John just noted, already some amendments have been put forward, and in his presentation, the Attorney General did say that he had some amendments to put forward, because this is going to be a bill that will have far-reaching impact on how justice is carried out. There were two recommendations made by the Law Association in their document captioned Comments by the Law Association of Trinidad and Tobago on the Evidence Amendment Bill 2020 that was circulated to us. One of the recommendations was related to Clause 12G, and the question is asked as to what happens if you have two suspects of similar appearance, the number of moving images. They asked that it not be reduced to 6, as was done in Clause 12G in the bill before us. The association went further to explain that the purpose of showing at least 9 photographs before identifying a suspect was to ensure accuracy of identification, as the more persons the eyewitness is shown and eliminates, the more likely the one who is fingered as the perpetrator would be, it would be more likely that that person would be the correct person. The rationales apply similarly for identification parades in 12K, where the same reduction was made for 2 suspects of similar appearance. As such, if a greater number ensures greater accuracy, the question is, what is the rationale for reducing the number of persons if you have 2 suspects that are similar? That's one question I would like the Attorney General to deal with in Clause 12G. The second is in reference to the process of involving the use of photographs to be recorded by video and that a justice of peace be present. This will assist in dismissing any suspicion as to whether the person making the identification was forced or coerced into selecting a photo, or whether there were any unusual eventualities. For example, if a person making the identification was asked, "Are you sure it is not this person?" when viewing a particular photo. So therefore, the recommendation is that there should be a video recording of this identification procedure so that it is clear that there is no coercion. I want to highlight that it was stated in one of the submissions by one of the legal advisory submissions that failure of a suspect to provide representation within a certain time can be detrimental to them, since the state can select the justice of peace to represent their interests. There's a great responsibility in addition to others, such as the one suggested in the foregoing recommendation. Therefore, the question, I want to make a mention of the call made by the president of the Justice of the Peace Association, Trinidad and Tobago, Mr. Don Ascarali, to discuss the training needed by members of this association with the Attorney General. He did mention that the justices of peace would require training, and this is something that the Attorney General should make sure that is done. Madam President, if we have persons who are expected to participate in processes that we are legislating for, but are not briefed substantively or sufficiently to understand why and how the processes work, we are inviting errors and we are inviting injustice to the people. Senator Vieira, in his contribution, hinted towards the training in the criminal procedure and practice in the third public meeting, and I endorse this as an earnest consideration for the relevant parties. Madam President, I do not wish to belabor the concerns raised by some of the stakeholders in the public meetings held in this bill, but I must state that I am in wholeheartedly agreement with one of the recommendations made by the Senior Counsel of the Legal Aid Advisory, that's Mr. Bill Gilbert Peterson, particularly the recommendation made for the defense to be allowed as part of the disclosure regime to view photos used in the ID process at a fixed time, either at the police station or the DPP office. This will ensure fairness to the defense and also confirm that there was adherence to the requirements stipulated for the nature of the photos to be viewed. Therefore, I endorse that this is a matter for further consideration in the provision under Clause 12B. Another concern is about the second concern I have is about the operationalization of the provisions. Madam President, the first point I wish to highlight under this head is regarding the storage of evidence collected. I see clarification on the place and procedure of storage of evidence. We cannot pretend that evidence does not go missing, and we want to ensure that, particularly given the fact that this is a new way of collecting evidence, we want to make sure that the evidence is also not stored properly, that it will not be tampered with, and also evidence would not be leaked. In discussing possible leakage of such information, some may say that since the people are suspects in a particular investigation, they are guilty, but we cannot assume that because the law says that you are innocent until proven guilty. I do appreciate that there was consideration in Clause 12Z that any person without lawful authority who possesses, plays, or offers to supply a recording of an interview under this division to any person, or who copies, tampers with, modifies, erases, or publishes a recording of interviews in this division, that there would be a fine. However, before we can delve into the details of the penalty, we need to discuss appropriate provisions under these divisions for proper storage, with sufficient checks and balances to ensure that there isn't tampering of such evidence while in custody, or that it can be taken out of custody and land in the wrong hands. Such tampering will no doubt taint the principle of fairness and will result in injustice. In a similar vein, when looking at the construction of the penalty drafted in 12Z, I must ask for a bit of clarity as to the circumstances in which lawful authority be granted to copy, tamper with, modify, erase, or publish a recording of an interview under this division, because it was said that it could be, permission could be given by the Commissioner of Police. Under what circumstances, I'm asking. The second point under this heading deals with the availability and allocation of resources to operationalize the provision of the bill. Senator John just made a strong point about that, and I think others would have done previously in their presentations. Issues related to ensuring that within the force, the police force, there are enough resources. We must ensure that there are enough video recording devices, not just in terms of numbers, but in terms of where they are placed. And in other words, within each division, that there must be sufficient police stations where the recordings are done, and that the persons who are doing it must have appropriate technological qualifications to support the processes where the video technology is employed or required to be tested for authenticity. So training of the police officers is important. Madam President, this bill seeks to bring us into the modern world regarding the admission of evidence, and it is to be commended. We must ensure, however, that the final product is capable of execution and is in the best interest of the people. I thank you.
Senator Naked.
Madam President, thank you for the opportunity to join this debate on this bill titled the Evidence Amendment Bill 2021. Madam President, I've used my one-week hiatus to do some reading, and I compared this version of the bill with the version which was laid in the Parliament in 2018. Having made the comparison, I would like to ask the most obvious question. Outside of the provisions dealing with witness anonymity, what has changed between this bill and the last version of it? The last time this bill was introduced, if I'm not mistaken, a special majority was required. So apart from witness anonymity, what has been removed from the last bill that would make this bill no longer require that special majority? Madam President, let me point to one of the reasons why a special majority is required for this bill. This bill is basically mirrored on the English Police and Criminal Evidence Act, or PACE. When PACE was introduced in the United Kingdom, the idea was to have it replace the judge's rules, whilst at the same time codifying much of the jurisprudence on the issue of treatment of suspects in police custody, identification procedures, and the taking of interviews and confessions. But in doing so, Madam President, the UK had a Section 76, which dealt with the test for admitting confession evidence, a Section 78 which dealt with exclusion of other types of evidence and also included exclusion of confessions which could not be excluded under Section 76, and to preserve rights and safeguards developed over the years under the judge's rules. They passed a Section 82, subsection 3, to expressly preserve those aspects of the common law not caught by pace. So there were safeguards. This bill before us does not make specific provision for the admissibility of confessions, but has an omnibus clause with the only criteria being fairness. And of greater concern is that we do not have anything resembling Section 82, subsection 3 of PACE, to preserve the common law. So in the absence of any clause in this bill to expressly preserve the protections developed by the judge's rules, by the common law, through the years, then it is obvious that it is subject to implied repeal. So all of the safeguards developed by the judges over the years, using the judge's rules, will be lost. All of the due process rights and safeguards to ensure fairness will be lost, gone. So if we had taken away those protections which ensure a fair trial, then how do we not need a special majority to do so? Since what we will be doing is abrogating rights, which is important to which inimical to the Constitution. Madam President, I've had no in-depth legal training, but when I look at this bill before us, I'm in similar company, it seems. I identified quite a few causes for concern with this bill. And although they are on the face of it, what that might at first glance appear as a handful of improvements, these apparent improvements distract from measures contained in this bill which are open to abuse. Madam President, I was able to do, quite fortunately, in my last semester at university in Washington, D.C., an internship, an all-female lawyers firm, and it allowed me to gain some perspectives on due process and fair trial rights and the importance of constitutional safeguards. As a result, it must be a cause for grave concern that there is a trend which started in 2016 and which continues to this day, a trend whereby we are bypassing the Constitution and the safeguards that exist in the Constitution. It started with the amendment to the SSA Act, then the Marriage Act, most recently the Procurement Act, and now this bill. Madam President, before I get into those aspects of the bill which causes concern, for good measure, allow me to say that I have very little concern with that part of the bill which deals with ID evidence, identification evidence. In that regard, the work of the Special Select Committee must be commended. I think a good job was done. My major concern with respect to identification evidence is similar to that expressed by preceding speakers. Whether we have the resources to make this work, and in that regard, allow me to express my deep concern with what I read recently about scholarship winners not able to find work. Madam, we can use this opportunity to make use of our valuable human resources. So I'm perplexed to hear on the one hand that we have too many lawyers, to the point that some are driving taxis, and then hearing that the Office of the Attorney General and the Office of the DPP are short-staffed. So by way of suggestion for the Honorable Attorney General, and to kill two birds with one stone, if we have these scholarship workers working with the Criminal Investigations Department in every division, we might see greater compliance with rules and regulations, which might turn or translate into more convictions, helping the poor conviction rate that we have. You see, Madam President, I have come to realize that we have been passing a lot of laws in this Parliament. And while we have the legal framework in theory, the reality, as so many of our former speakers stated, is a very different story. By way of example, when I watched the contribution of the Attorney General, I heard him make reference to a national forensic DNA data bank. And I have to ask the Attorney General whether he's aware that there has been no DNA analysis taking place at that Forensic Science Center since January 2018. Madam President, I won't call the name of the case in Parliament for obvious reasons, but I will pass a note across the aisle so that the Attorney General would have the evidence of what I'm saying. We heard about a virtual court hearing and heard a chief magistrate express a total shock when the analyst who came to give evidence told the court that the machinery has been out of compliance since January 2018. So this is not a hearsay story, Madam President. This is direct evidence that while we would like things to be different, in reality they are not. And this is not an isolated occurrence. It is apparently endemic across the entire criminal justice system and beyond. So that is why I was a bit disturbed when I heard the Honorable AG say that there are provisions for partial proclamation of this bill when it becomes law. Because we had electronic monitoring legislation, and it took more than 5 years to operationalize. And I'm still not certain that it is being used. So I would like the Attorney General, when he's wrapping up the bill, to tell us which parts of the bill would be partially proclaimed, and how soon thereafter would other aspects of the bill be proclaimed. I'm particularly interested to hear whether that part of the bill, which deals with the videotaping of both ID parades and confessions, would be proclaimed first. And if not, how soon can we expect these parts of the law to become reality, since these are the things that affect the common man? On both sides, as my honorable colleague Jolene John said before. Because it has come to my attention that audio and audiovisual interviews of suspects have been used in evidence before, without the need for this legislation, so that it means the police should already have the equipment up and running from minute one, ready to go. I understand that video-recorded ID parades have also been admitted into evidence in court, right here in Trinidad, so that I hope we can again hit the ground running. And I cite the case of the DPP versus Chauvin Toussaint. But again, Madam President, even if the police have all of the equipment, there's no guarantee, in my mind at least, that they will use it, because there are no real sanctions if they don't. In fact, Madam President, I'm quite disturbed by the proposed section 12Q of the bill dealing with interviews and oral admissions. 12Q, subsection 2, gives the police an opportunity to avoid the strictures of the act. And it reads, an interview shall be recorded by video recording unless it is not reasonably practicable to do so. Madam President, why would it not be reasonably practicable to record a confession or interview of a suspect? This allows the police an excuse to not bring what is the best evidence, which may be detrimental to the accused and result in unfairness. The police should have no excuse. They should be provided with the equipment and not be given any opportunity to depart from what is best practice. In fact, I'm even more disturbed by section 12Q, number 6, which states that the interview is to be taken in writing if it is not reasonably practicable to record it by video audio. This allows the police to come into court and give any number of reasons why they couldn't record an interview or confession either by video or audio. So we are back to square one. In fact, Madam President, I am told that the Homicide Bureau of the Police Service has been equipped with micro-cassette recorders since 2001. And only in one case, State versus Daniel Agard, has audio recording been used. So what really is the sanction for not making use of what we are going to enact? The possibility of the evidence being excluded is not an effective sanction in my mind. It's like throwing the baby out with the bathwater, Madam President. So again, I have a like concern with with Section 12(3) subsection 2, which is open to abuse and it can result in unfairness to the accused. You know, where the interviewee, he objects to the video and the audio recording, and then the interviewer turns off everything and writes the rest of the interview. It's just too loose, Madam President. It's just too loose. And I can speak, to be honest, to my experience in Lebanon. When I advocated for African players, I was brought in on a case of sedition almost. And they tried to write it down in Arabic. And you know, in Arabic, as the Honorable Attorney General will know, one character can make a difference. One character, and they tried to do that. So if I was not alerted, the writing down of these things can be very, very detrimental to a defendant. Similarly, in Section 12AH, can the Attorney General advise as to the justification for removing the judicial discretion in this instance? Use of the word shall is mandatory. As we know in interpretation, and may gives judicial power a bit more latitude, and this is important. The police are equipped with body cams, but they outright refuse to use them. This equipment is for the protection of both the police and the citizens. But we continue to have police involved in shootings and have to rely on footage from private citizens. So unless we add or strengthen existing sanctions to ensure that these measures work, then we're blowing smoke in the air, Madam President. We will have the law in place, the equipment in place, and they may end up as useless as the procurement office. Madam President, with respect to that part of the bill which deals with confession evidence, I have some concerns which I will share with you very briefly, since I would like to get into some weightier matters if time permits. I note that we are replacing the judge's rules and all of the jurisprudence that goes with it, and I understand that judge's rules are somewhat anachronistic and change is welcome, but here's my concern. The taking of a confession is being governed by statute. What happens when there's a breach of that statute? When the dictates of that statute are not strictly complied with? So I saw the advice of a few trial lawyers, and I'm told that there are several avenues for exclusion of confession evidence, some of which also applies to ID evidence and other types of evidence. I find it a bit awkward that we might be faced with a solution where the police might be in breach of a statutory requirement and the judge having to say, well, in spite of the police not following the law, or put another way, the police actually breaking the law, but the judge would like to still admit the evidence. That places, in my mind, that places a judge in a rather invidious position.
Senator Naked, you have 5 more minutes.
Thank you, Madam President. I'm also concerned that the prosecution would seemingly be able to rely on the video recording as evidence, and the accused doesn't get the chance to cross-examine the persons who played a part in obtaining that confession. And there's a notorious case of the Central Park 5 in New York. They had video-recorded confessions, although DNA evidence later showed that they did not commit the crime. They were induced and coerced to do so. So this shows why, in my view, it is important to have all witnesses who played a part in the taking of the confession available for cross-examination, because no one knows what transpired before the confession was taken or the treatment of the accused prior to taking the confession, either by way of threat, of unpleasant consequences, or inducement. Since I'm left with little time, Madam President, I'm concerned about removing judicial discretion, as I see in 12Q, subsection 11, and 12.5c, parts of the legislation being expressed in mandatory language. When we say the evidence shall be admissible, it is clear that the discretion of the judge is removed. Should we not use language which recognizes and preserves judicial discretion? So I will move, Madam, really and truly, I have to put on record that 20 minutes is not enough for us to discuss this. But anyway, I close by pointing out in brief, Madam President, the judges have been using the common law and their inherent jurisdiction to ensure fairness, without the need for many of these proposed amendments, without being restricted by the four corners of a statute. Let me itemize briefly for the Attorney General what the courts have used without the need for statute. In the matter of CCTV, we have the State versus Robert Leacock. Special measures, we have State versus Apollos Alexander, 2014 trial. And Barry Alphonse in the 2011 trial. Video recorded ID parade, we have State versus Chauvin Toussaint. We have in the audio recorded for confession evidence, the State versus Daniel Agard. I make this point in closing because as I understand it, the judges, through inherent jurisdiction, have employed all of the measures that I just outlined without the need for legislation. So I have to ask, since we have no evidence of abuse or misuse brought by the Attorney General, what is the justification for enacting a statute which can have the effect of tying the hands of judicial officers who up to this time have succeeded in making use of many of the measures we now seek to enact? Madam President, in my view, the language is too loose. It actually places our judges at a disadvantage. And as my honorable colleague, Senator Julian John said, we absolutely reject this. I thank you very much.
Senator Diyal Singh.
Thank you, Madam President.
Senator Diyal Singh, before you, okay.
Sure, thank you. Thank you, Madam President. Madam President, I realize that crime continues to plague our nation, despite the best efforts of our ministry, or the Minister of National Security and our Commissioner of Police. And to deal with crime, this piece of legislation will help us in a certain degree. But then we also need to tackle the social causes of crime too: poverty, teenage pregnancy, drug use, unsupervised youth. So with the COVID economy and with the fact that the allocation to the police service was also diminished, we see this, any sort of fight against crime is a little more challenging. I think, Madam President, the Minister of Family and Social Services has a greater part to play in this regard of preventing a new generation of criminals. You see, every generation is getting younger, more vicious. I see little skinny teenagers carrying guns heavier than themselves. So we have a society who have nurtured, pampered, and created some of these criminals. So we now have to put legislation in place that put programs in place to help the new criminal element from coming, the younger ones coming to the forefront. Also, we need to set examples for the present criminals. And I see this piece of legislation would help us to set some examples to those persons who are looking on. The youths who see gang leaders who, flaunting their bling, their chains, their money. The youths who see that, gang members, a few gang members wreaking havoc in our nation, even meeting, as I say, previous prime ministers and even the commissioner of police. So this bill will hopefully, if we have the evidence that could be presented in a way, this bill could hopefully send a message to the youth there that, we are now serious about getting you in jail where you belong. We are now serious about getting the criminal activity, which seems to be the only industry thriving. Because, Madam President, there are new commodities in our land now, high-grade marijuana still entering the land, where are people getting the US dollars to bring these in, the guns, the crystal meth. So I'm happy to see recently the assets of a deceased drug person seized by the court. So kudos to the Attorney General and the previous Attorney General, Ramesh Maharaj, who first introduced legislation to that. So therefore, I hope that the fact that we are dealing with this evidence here, admissibility of evidence, we are looking at certain factors where police procedures in supply, police procedures are set out in law. Video evidence is put in a way that, what could we use, what we can't use. And even we are looking at the eyewitness, the whole idea about the eyewitness. But, Madam President, I am not too impressed with the whole eyewitness scenario. And I want to just quote, if you permit me, there's the Innocence Project, which in the United States, which actually looked at cases where people were exonerated. They were, since 1989, there was what we call the DNA exoneration, where you had eyewitness accounts actually showed that persons were in jail, but when they reviewed the DNA evidence, 367 DNA-based exonerations were found that went against the eyewitness. So therefore, when you look at those persons and the average number of years served, 14 years most persons served, and it affected about 140 persons. So definitely, this report looked at the miscarriages of justice, and they mentioned eyewitness misidentification as one. Also, forensic science, not being properly, done or unvalidated. Also, false confession and admissions, government misconduct, informants, inadequate defense. So it begs the question that even though we are concentrating on the eyewitness report, we may have to rely more on the DNA evidence. And as Senator Naked did mention, we need to actually get this DNA legislation going. And, Madam, what I may say is that the section looking at video evidence and the CCTV cameras, I think it's much needed because, if you look at the level of crime we have, if you look at social media, you would be seeing individuals going into places and committing crimes, committing robberies. And, some of those, when you look at those, it's difficult to identify them. So even though this piece of legislation looks at eyewitness, look at identifying, even look at the CCTV cameras, most of those bandits now are more masked up than the persons who attended Tyrico or even Queen's Hall. The bandits are coming with masks. So how are we going to identify them now? Because the eyewitness will just be seeing a hat and a mask. So we have to depend on other evidence. Most of them, however, and it's a suggestion I'm hoping that, that the Minister of National Security look at, the bandits will go, they have on their masks, so it's difficult to visually identify them if you are eyewitness there or even from the cameras. But most of them go without gloves. So the fingerprint experts need to be there. The DNA evidence that they may be dropping certain things need to be there. Plus, I must say I was happy that the CCT, evidence could now be brought into court. But you see, we also need a wide spectrum of camera surveillance in Trinidad and Tobago. The eyes have to be all over.
So, Senator Dial Singh, if I could just give you a little guidance. The bill is very specific about certain interventions, and you're talking a little outside of the remit of the bill. So I'd ask you to direct your contribution to the bill itself, please. Okay?
Thank you, Madam President, for your guidance. But, Madam President, I just wanted to bring the idea that even though the bill has looking at eyewitness, it's not that reliable, and we may need to go a little further in this aspect of looking at the reliability. If we have to put a dent in crime, we have to say, yes, this legislation is needed, but we need other things also. So I must say that, Madam, that when I looked at the the bill and I heard the contribution of other persons, I was very happy when I heard the contribution of Senator Hazel Ahi Thompson, where she gave a real-life experience where her lawnmower was stolen and her husband actually went after it. But I may also, if you permit me, to talk about a real-life experience, please, where around December, my wife was shopping, and I was in Val Park, and she got her ATM machine, and she put it in her trunk in a brown bag, and in 5 minutes' time, when she went to the grocery, somebody actually broke into the place, her car, and got the machine, thinking it was probably money. Now, the thing there, police responded quickly. We had the camera footage, but the persons had on masks. They were able to trace the car, but it was an identification plate that was false. So even though we had video footage, even though you had the ability to look at those individuals, we were still fell short because we didn't have that parameter outside to follow these individuals in the car. So when I look at the bill and I see the bill has 12 clauses, and looking at the identification of suspects, the electronic recordings of interview of suspects, provision of special measures to allow testimony to vulnerable witness. And I'm very happy that that aspect of the bill was there, because you find that sometimes victims, are re-traumatized when they have to face their perpetrator in court. And this especially happens in cases of like rape cases and whatnot. And we have already seen that in cases dealing with children, the law is already there to assist children for not facing certain abusers. So it's not to say it's new or novel legislation we are getting. We are getting pieces of legislation that have already existed. And I looked at the amalgamation of existing legislation of the identification. Looking at the legislative framework given to the powers of the police, from the judge's rules, which was produced in the context since September 1994. And I remember the late Aeneas Wills and my father, Lennox Yeltsin, talking about judges' rules, and they were assize court judges then. But here you have now, the police are able to look at the judges' rules, the Code D of the Revised Code of Practice of Identification of Police by the PASTE Act from the United Kingdom, and also Blackstone Criminal Justice Act, the Turnbull Guidelines. So all these guidelines are now put in one place, and I support it. Because what it means now, the police officers would have guidelines that I think they could now go at, and also I'm hoping that when those police officers are doing their training, they could be trained adequately in the proper identification process. Because remember, those were issues where court cases would have fallen short because of the identification processes. And what I might say, Madam, the different divisions that I've seen here, I've looked to see, here we are trying to protect the eyewitness in certain instances, which is good, because I'm thinking you have vulnerable witnesses, you have the fact that, some persons may be scared to come to the courts, and you have that protection leveled, given to the witnesses. You also have protection in terms of the separation of the identification officer and investigation officer, which I think it's in a good direction. Because you see, mischief were sometimes created before. I remember a case where an investigation officer went after his wife's boyfriend, and he was the investigating officer, and he was also the identification officer. So the parameters for the identification parade, as set out with different priorities, I think it's very welcome to go from one to the other. The fact that you have, I mentioned, the identification officer being different. And I'm saying, Madam, we may have to reach a level where we have a team of identification officers who just does that, go to different police stations doing just the identification. So they're experts in putting their witnesses. They're experts in actually having the photographs. They're experts in that field, because sometimes you may have another officer in a station making mistakes. So we have to reach that level where we would have that. So I also look with this COVID situation, and I realize it's sometimes difficult for an ID parade. If you have 12 members of the public standing next to each other, it's against the COVID regulation. So I'm thinking this whole idea of having the video identification is needed in this time. And I could sometime envisage a world, e-world, where sometimes there are no more missing diaries, because you know, missing diaries, missing pages was something that, you know, we had, or still probably may occur, I'm not too sure. But, you know, a drug don could pay someone to even put a virus in our computer system. So as mentioned by Senator Dylan Remy, we have to ensure that we have hard copies of whatever computer documents we have, protection that, you know, it would not be able to be wiped out, because that is now how the evidence would tend to be in the future. I also looked at, Madam President, the fact that Clause 9 of the, you know, dealt with the consequential amendments necessary in the light of modification of Section 40, which computer admissibility of evidence for civil matters. This I support, because we know a lot of crimes of fraud actually deals with a lot of computer evidence. So I think we are keeping up with times with this bill. Clause 12 deals with the introduction of the FIU unit, and it actually helps the law in that part. And I know the Attorney General is at pains to try to get the FIU moving and following the money, and I think this, again, works in with this. Section 12G3, Madam, looked at a minimum of 9 hours notice to be given for someone when they are to deal with the, when they are getting notification for the conduct in terms of the identification procedure. I am thinking we may need more time with that, because you see, if somebody is held 4 o'clock, they are given a notification that we are going to do a lineup tomorrow. 4 o'clock, you may not be able to get your lawyer's office open at that time, and if 9 hours is lapsed, I think now it'll be a disadvantage. I think it's more reality 24 hours, as I'm saying, that we could give the time for the individuals. I'm saying, Madam, if we have a country where you have station diaries, pages disappear into thin air from police stations, and also, we have to ensure that if we are given video evidence, I'm wondering what is the possibility of individuals having their phone and being able to, since money is a problem, most police officers have phones. What is the practicality of telling them now we could probably use your phone to videotape the whole process, and then you could put it into the computer to at least save it on a hard drive? Because I'm saying with these economic times, we may not have the ability.
You have 5 more minutes.
Thank you. Yes, thank you. We may not have the ability to have video machinery at different stations. And I have had persons coming to me, members of the public, saying that, they are traumatized when they have to go to court. Members of the public sometimes come to me trying to get an exemption from jury service when they figure that they have to go to court. They may be dealing with some criminal element which may, who may somehow reach to them. And you find that sometimes, we may have to think of a system where we also have to protect members of the jury, not just the witness, the eyewitness, but probably we may have to look in the future where we have the juries are screened by the attorneys and remain anonymous throughout the proceedings. And, this name it jury 1, jury 2, where they are not being seen or known to the public. This is something, if we are looking at this legislation to protect eyewitness, if we are looking at this legislation to protect others, we have to think about the jury also. And as I said, I welcome this. I see the whole idea of video footage. Car cams are now could be helped in car accidents. Section 12Z creates the offense of a person who disseminates, copies, modifies, or erases recordings in the interview. This actually takes into account that, hey, if diaries could disappear, it punishes those individuals who will interfere with the evidence. And I see at least, the fines are there, heavy fines, that at least the AG understands our culture. Some diaries could go missing, or some evidence could fall into the wrong hands. So I must say that these pieces of legislation this legislation is something I would support, and I think that in this COVID time we need it. In the times of the criminal having the upper hand, I think more than ever we need to put in mechanism in place that we could deal with the crime. But I'm also suggesting that we may have to look at other things like the DNA, to at least to get a holistic approach to, to deal with what we are dealing with in terms of the criminal element having the upper hand. I thank you, Mr. Vice President.
Senator Leiter.
Thank you, Mr. Vice President, for the opportunity to contribute to the Evidence Amendment Bill 2020. And Mr. Vice President, I would have had the opportunity last week to listen to my colleagues, Senator Mark, our lawyers, Senator Lakshmi Dayal, and our temporary Senator Rambajan, not Rambachan, dissect this bill and show many of the shortcomings, the challenges and the lacunas in the bill. And Mr. Vice President, I listened to my colleagues today continue showing these shortfalls. But for me, Mr. Vice President, I come here today to contribute to a bill that once again tramples on our democracy. You see, Mr. Vice President, it is very disturbing that this government repeatedly tries to circumvent the 3/5 majority for passing of parliamentary bills in matters which affect the constitutional rights of individuals and citizens of Trinidad and Tobago. And Mr. Vice President, while we appreciate the fact that the government is eager to pass these bills without any opposition, there is a reason why a 3/5 majority is required. You see, Mr. Vice President, constitutional rights of individuals, as enshrined in the Constitution, are rights that are sacrosanct, or that are the highest rights or laws of an individual in the country. Mr. Vice President, the people who framed the Constitution were of the view that there be a majority in the Parliament voting on any issue that interfered with your rights. And that is why bills such as these, the Evidence Amendment Bill 2020, which interferes with those rights and privileges, requires a special majority. So, Mr. Vice President, whether we are here talking about the rights to congregate, the rights to religion, the right to movement, the right to the equality before the law, equality of treatment, these all require special majorities. And a bill of this nature, which goes to the root of an individual's freedom, equality of treatment, rights to just treatment of the law, rights to legal counsel of your own choice, rights to due process, all require 3/5 majority. But Mr. Vice President, In typical fashion, the government has found what they think is a clever way to find a loophole to bypass the special majority. And they think that by passing it, they think they have cleverly succeeded in avoiding the opposition or not having to get our consent. Effectively, what they are doing is they are taking away the safeguards of the Constitution, which were designed to protect the citizens of this country. And if the government, Mr. Vice President, is intent in passing laws that requires 3/5 majority and circumvent it by using a special majority, then what is the purpose of the opposition contributing here today? Is it simply merely for the fact of putting on a rejection on opposition on Hansard? Is that why we're here? But, Mr. Vice President, the opposition, being the watchdogs of democracy, are here to protect the rights of the citizens. And it is our duty to expose the bill as an act on the behalf of this government to undermine the rights of individuals of Trinidad and Tobago. And especially when we look at the amendments proposed in Clause 4, which amends Section 12 of the Act, it is very worrying for the opposition to see an attempt to erode the rights and the privileges of people that are enshrined in our Constitution. And, Mr. Vice President, let's get this clear. While the opposition is very concerned about crime, and while it is our intent to always support good legislation that seeks the interests of our citizens, this opposition is often vilified for not having participated and supported badly drafted legislation. Because, Mr. Vice President, if the Hansard is to demonstrate who the opposition is, then it would show that the opposition is a body of persons who have stuck to their oath in ensuring that only good legislation is passed, and we don't simply pass legislation as a plaster for a sore. Because interfering with the rights of citizens is not a simple matter, Mr. Vice President. It's a matter of grave concern. It's not a matter of convenience, and it is especially not just about how many laws we could pass and beat my chest as to how much we could pass. There's no Guinness Book of World Records here. But, Mr. Vice President, it's our duty to contribute, and I will raise a few issues. So, Mr. Vice President, when we look at the new section 12B to be inserted, this section makes reference to photographs for the purposes of identifications of suspects. Now, Mr. Vice President, this is all well and good, but how do they propose to implement it? There is no definition or explanation in the Act to outline how they intend to use photographs. In other words, what is going to be the database? Even when we reviewed the draft regulations that were given to us less than 24 hours before last week's sitting on Tuesday, which are very vague, we still don't see it there. Is it going to be comprised? Are these going to be comprised of up-to-date photographs? Is it going to be just anyone being put in this database? Are they going to put a picture of my good friend, the Minister of Agriculture, who's coming up next, gearing up? Are they going to put a picture of him there? Or any other line minister or an opposition member or someone in the Independent Senate? Are they going to use photographs from the Facebook? What photographs are they going to use? What happens if they put a picture of our beloved President of the Senate inside of there?
You may not have known this, but we don't use the President of the Senate in a debate.
A beautiful picture of a beautiful lady or any other person being put there, would that person agree with that? Or what if, again, coming back to my good friend, the Minister of Agriculture, what if his picture appears and someone says, hey, that is the person that robbing me? What is going to happen? That's the person robbing me every night. He just eat doubles on the corner. He robbing me every night. Is my good friend going to be accused, possibly accused of a crime, without him even know his picture is there? That would warrant some sort of an investigation. So there must be some semblance of an understanding as to how does the photograph first make it to the database being used. Because, Mr. Vice President, it creates dangerous precedent of random photographs being used. And there is no explanation as to in the system. And I think that this is an important factor that must be reviewed. You see, Mr. Vice President, there is a difference between what is proposed in Section 12 and what obtains in present in an identification parade. You have to voluntarily agree to go into an identification parade. So if a policeman see me at the side of the road and say, Mr. Leiter, Senator Leiter, you know, we would like you to come in identification parade, and I agree to do so, I'll be doing so and submitting to that on my own will. But in this particular instance, we are not seeing where the person agrees to put their photos inside of there. Now, Mr. Vice President, I am not trying to be facetious when I bring up my partner, my good friend, the Minister of Agriculture's name, or anyone else in this conversation. But it is the government and the ministers here that are going to vote for this today, you know. So I have to bring it down to their level and bring it home to them. So I'm simply asking, what is the criteria to be used for photographs? How are they going to compile the photographs? Will people be notified of photographs being on the system? And lastly, if they use photographs for comparison purposes, because part of the process is that they use comparative photos to show people of similar like and such. Are they doing it in such a way that a suspect or defendant will be given disclosure? Will the suspect or defendant be provided with information as to which photos they use, or will it all be a secret, veiled? But, Mr. Vice President, photos is one matter. But when we look at video recordings, Mr. Vice President, when we look at Section 12J and beyond, in terms of video recordings, we see we're going to have video ID parades, videotaping of interviews. But the big issue here is, where are they going to buy these video recording machines, and how is it going to be properly accredited? Are they going to go down to courts? They're going to go to my Detour Tech? They're going to order it off of Amazon? Some guy in a trench coat will sell it at the side of the Parliament? I don't know. I mean, who determines the integrity of the system, Mr. Vice President? That is not subject to being tampered with. It's not subject to interference, not subject to manipulation. We see how easy it is to manipulate video recordings today. This bill provides no explanation as to what will be the source of the equipment that will be used to handle the recording of these recording devices. Because, Mr. Vice President, if these recording devices are going to be used for the interview process, a process that could determine the innocence or guilt of any person, and there's nothing in place to determine the integrity of the system, that to ensure that no one can manipulate or interfere with it, with the recording in any way. No voice manipulation or anything that can undermine someone's interview. Then there's a serious problem at hand, Mr. Vice President, and it has to be addressed. So where is the equipment coming from? The man on the side of the road? What is the process in terms of safeguarding these recordings? Where are they going to be kept? In the age of technology, Mr. Vice President, these are all risks and concern. And Mr. President, while there is a provision in Section 12K, subsection 10, for a copy of the original recording to be supplied upon request to the suspect or his representative within 7 days, the history of how things work in this country, Mr. Vice President, has shown that although disclosure is meant to take place, very often the police does not disclose. And, Mr. Vice President, what is the consequence of not disclosing in a timely manner? Mr. Vice President, you know, we also look, you know, the government would direct us also to Section 12V, where the Commissioner has the responsibility to ensure that all master copies are kept securely. But there is no provision for several aspects of the storage, namely, what is the system if they are misplaced? What is the mechanism to ensure the integrity is protected? See, this is critical for prosecution, Mr. Vice President. This glosses over how you secure the recordings and the responsibility of the Commissioner. But we need to know a little bit more before we can speak further on that. So, Mr. Vice President, this is not a simple case of buying a gun or a pair of boots. Yes, they're all tools to fight crime. But if you are interviewing me and my rights are likely to be infringed by the process, a process that can determine my innocence or guilt, you should make every effort to ensure the integrity of the process, that there can be very limited room for error. There's our no reference to auditing mechanisms. vague reference to the safeguarding of the interviewing record. No procurement procedure that will verify that to ensure that there will be zero manipulation. You see, Mr. Vice President, while devices are indeed being used internationally, there are safeguards that are put in place in other jurisdictions. And so we see that the government has somewhat mirrored the UK 1984 law, the PACE legislation, but Britain has very stringent measures in place, such that even the best lawyer cannot penetrate these types of recordings. But if you leave it open, without defining it, every lawyer will start to challenge the system. They will say things like, what is the recording? Where you obtained that? Who you got it from? These are issues that will undermine the process. And Mr. Vice President, in my research on the UK pay system, there was actually a company that worked very closely with the UK government to assist them in forming the legislation as it pertained to video recordings, and to put the specs of the equipment required in keeping with the integrity of the interview. So this particular piece of audiovisual equipment would have a burnt timestamp of the interview onto 3 DVDs. And once the interview was completed, the 3 DVDs would be timestamped and you could not record over it. I didn't hear that here. 1 disc will be given to the magistrate, 1 will be given to the defendant, and the other will be given to the prosecutor. Here I'm only hearing about the Commissioner of Police. And Mr. Vice President, I believe, if I'm not mistaken, I heard my senator colleague Nakid speak about these machines being used. I think it was about even 10 years ago that the government of Trinidad and Tobago had actually procured 12 of these machines, and it was being used at national security in the time. But they hadn't passed the legislation at that point in time to be able to use it as evidence in court. But now these 12 machines have disappeared from my understanding. And we understand that the TTPS is indeed interested in purchasing more of these similar machines. And welcome back, Madam President. And Madam President, due to budgetary constraints, they couldn't do it under this government. Madam President, we heard of a cut of over $300 million.
Senator Nakid. Senator Leida, you have 5 more minutes.
Thank you, Madam President. And we heard a budget cut of over $300 million to the TTPS. So I understand the Commissioner is struggling to pay last year's bills. We all know that the police service is underfunded. They are lacking resources. This type of equipment requires a system with integrity. It is an expensive system. It is a system that requires service level agreements, training, upgrading. It's not, this is not a camcorder. Is it that the government is going to allow the weakness of the legislation, coupled with the lack of funding with the TTPS, to allow substandard equipment to enter the police service where people's rights can possibly be infringed? Again, it is not a gun. It is not a pair of boots that we're buying. This is something that could make or break a person's innocence or guilt. There's a famous saying, Madam President, it is better to let 10 guilty men go than to have 1 innocent man convicted. And Madam President, we cannot forget that there is currently mistrust by citizens in some of the TTPS. And Madam President, despite the valiant efforts of the Commissioner of Police, who vowed to clean up the rogue elements in the police service, and Madam President, he's done a fantastic job doing it. But even he will admit that his job is not yet complete, and there are still rogue elements. But we are confident he will get there. But until such time, people can still be set up by rogue elements. Madam President, in another place, there was a minister who claimed that certain police reported to him. But I won't bring that here. I won't go there with that, Madam President. So here we have something that could be manipulated if you do not put measures in place to ensure the best type of equipment is going to be used. If that's allowed to happen, you're going to have citizens whose rights will be infringed. Then you will have defense lawyers insisting that clients should not submit to these video interviews. Then this bill goes nowhere. So if the government is going to give lawyers the opportunity to direct their defendants not to submit to the interview process, this whole law just adds up to a rubber stamp exercise of failed legislation. achieves nothing except to say that you passed the law. Another piece of flawed legislation that has been passed and goes up on the shelf without achieving anything. So, Madam President, I also listened to Senator Naked and Senator Dial Singh speak about DNA evidence, and they made reference to that there. And I bring reference here to that as well too, because that too is an important piece of evidence to be used. That is science. That is what every country in the world is using now to convict persons. And I want to clear up something for Senator Naked. It was indeed 3 years ago that DNA lab was completed and ready to go. They had to be accredited by an international agency. They were accredited 3 years ago. And my understanding, it was only 2 weeks ago that the Minister of National Security actually approved it. I understand it's still waiting the AG's signature. I understand it's still waiting a cabinet note to be approved in cabinet. Why is that DNA lab not open? We're hurrying this bill, but we're not looking at other avenues to convict criminals, Madam President. So, Madam President, as I conclude, this legislation is consistent with the rushing of pieces of legislation that is rubber-stamped and not thought through properly. One thing that this government is consistent with is passing bad law. This is why the opposition continues to object. This is not a personal attack against legislation or the law. It's about passing bad law. We continue to see the government passing legislation that erodes the constitutional rights of our citizens. And when we oppose them, they say we are unpatriotic. But if the government wants to be patriotic, some of the members on the side of the PNM have to agree to not pass this type of bad law too. They need to take their own people to task. Because in the words of Theodore Roosevelt, who said, if you really want to be a patriot of your country, patriotism means to stand by the country. It does not mean to stand by the president. And in our case, it doesn't mean you have to stand by the prime minister and his 4 horsemen. So at the end of the day, Madam President, the rights of citizens are paramount. The constitutional rights of citizens are of most importance when you're in government. And as such, Madam President, on this side, the opposition will not support this bill in the manner in which it is. I thank you, Madam President.
Culture, Land and Fisheries.
Madam President, now that Senator Leida has declared our friendship, I take the opportunity to offer some friendly advice in possibly reshaping that quote from Theodore Roosevelt. I would say, if you want to be patriotic, you have to speak the truth. Because speaker after speaker from the opposition bench have this habit of talking about passing failed law without a shred of evidence. Madam President, when I read the newspaper, I feel a sense of pride and accomplishment when I see the work of this Parliament. And it's not just this Parliament. The Parliament backed by the people who work here on the work product produced by the Honorable AG's office and his team, backed by public servants across the country and experts around the world. When I saw the first judge without jury case completed, I felt we had done our job. When I saw the sexual offenses legislation put to work, the amendment. Remember us discussing for a very long time this issue of a parent or a person in a position of trust failing to report. And we settled on making it an offense. And I was very pleased to see someone charged under that legislation. We had a lot of debate about the marriage amendment, child marriage. And I felt very happy recently to see a father charged, having fathered 3 children with his daughter while she was a minor. And in that story, the young lady was being interviewed, and she talked about how her life was lost, in particular education prospects. Bail and anti-terrorism, the refinement of the FIU, and numerous legislation. Yes, we've made errors in some and we've come back to the Parliament. But there's absolutely no evidence of this litany of flawed legislation by this government. Madam President, I thank you very much for the opportunity to speak on this bill. And very quickly, I want to address 3 areas. 1, the architecture of the bill. 2, the background to the amendments, some of the history. And 3, the work of the Select Committee. And reflecting on some of what was said before, I want to say to Senator John that I'm sure the AG will address, since he has more time than I have, the issue of the bottlenecking. But I could say with certainty, particularly the work done to remove preliminary inquiries, to expand the courts, the availability of court, the staffing, numerous, the amount of things that have been done to deal with this backlog and this bottlenecking. I'm sure the AG will get to it. Senator Naked, the issue of special majority and safeguards being lost just does not arise. It just does not arise. And towards the end of your contribution, you did in fact say that the judges' rules are by and large preserved in the legislation. Senator Dialsing, I could assure you that the DNA legislation is in place, and in this Parliament we've dealt with the DNA data bank and the regulations. And Madam President, I want to talk about the architecture first, because we could get very, very sidetracked and get lost in what this bill is about. This bill has 12 clauses, and the first 3 are, of course, procedural, but clause 4, is really where the meat of the matter is. And clause 4 addresses 4 major areas. 1 is the area of identification procedures, and that is in 12A to P. And Madam President, I heard Senator Leiter talk about photographs as though it was something new. Well, my mother follows the Parliament, and it's the first time she'll be hearing this story. But when I was still a schoolboy, I accompanied a colleague to the police station on Harris Promenade in San Fernando. He had gotten himself in a little skirmish. Not the Honorable Attorney General. He was a good guy. And the young man had to go through this binder. And we were young, so it looked like 20 feet tall. This massive binder of black and white photos. And after about 5 minutes, everybody started to look the same. I don't want to get into stereotypes, but it really struck me then that there's one fear that is correct, Senator Leiter, that in selection of photographs, you really have to be careful. But it was a binder of almost like the same person over and over, and we must have looked up at about 200 photos where I persuaded my friend to abandon, because there was no way you could use this. So photographs have been around for a long time, and for those of us who passed through the law school, the Turnbull guidelines was something that haunted us, because we always felt that you could be placed in that position with this fleeting glance. I'm sure Senator Roberts, for example, would hate to be mistaken in a video, in a photograph or something, or a scenario. And nobody wants to be mistaken. So that what 12A to P does, and the AG has been very good to include in the package the regulations. We don't normally, we are not always in a position to provide the draft regulations, but in this case, the draft regulations of the ID procedures have been circulated. And that, Senator Leiter, contains the level of detail that will guide the process. But the ID procedures is really meant to do two things. One is to make for a successful identification of a potential criminal, but also throughout balancing the rights and ensuring that the safeguards are in place. And in every jurisdiction, the decisions of the court, the written decisions, are replete with cases in which errors are made because you're dealing with human beings, you're dealing with active crime scene, and you're moving parts, and you're moving with different levels of understanding of the law and the procedure and so on. But by and large, and of course, in criminal procedure, there's always this tussle to specify and to be prescriptive, but to also leave room for what happens in the actual investigation and the actual procedure. It is sometimes dangerous to be prescriptive, but I am confident that what the AG is attempting to do is to finally place into statute, supported by regulations, what essentially have been practiced in the courts for a long time. The second area deals with the interviews and oral admissions, and of course, and if you really want to read the criminal law cases, you would find that this area, interviews and in the handling of disclosures and admissions, tend to be the point in which prosecutions fail. And it is something that the introduction of video and audio recording should help us. And I understand Senator Leider's lament about equipment and so on, but this is not a procurement bill. I always say that as legislators, we have to do our job. This is framework legislation that is going to be supported by regulations, and it's going to filter down through the administrative and the bureaucratic process. We ought not to worry ourselves about whether the camera is going to be working. We have to put the horse in place first. We have to put the horse in place first. We have to get the machinery going before we leave it for somebody else to work out, to manage the procurement. There are rules relating to the procurement. You can't, for example, if we were doing a bill related to the health sector here, we can't be speccing MRI machines and so on. That is not what we do here. And the third area, Madam President, deals with the special measures, and those are 12AA to 12AG. And the missing one compared to the bill that was laid in 2019, the missing element of that is, of course, witness anonymity, that I personally and professionally would have liked to see in our legislation because of the time and because of the state of the country, but we have decided to exclude that in this form of the bill, and I will speak about that when I speak about the Select Committee report. And then in the fourth area, the thing that attracts me the most, of course, is a provision in 12AH that finally, and I don't know why it has been so complicated and why it has taken so long to simply address this issue of admissibility of CCTV evidence in criminal matters, and I'm happy to see it at 12H. So that essentially is the architecture, Madam President. And I want to talk about the history of the amendments because I listened very carefully to Senator Leider, but because he spoke a week ago, we may have forgotten the tone and content of Senator Mark's contribution and the usual package we get from Senator Mark, to which I would refer. But I want to say, Madam President, it's been more than 20 years we've been at work on this evidence amendment bill. The amendment in 1999 was simply enough to include forensic document examiner and forensic biologist and so on. But in 2006 is where we really went into the significant amendments. And in 2006, in that bill that was passed in March 2007, it addressed the issue of written statements made by a person in criminal proceedings and the admissibility of written statements where the person is not present for the trial because they are unable to be present because of physical issue or mental issue, or because, Madam President, they've been kept away from a trial because of threats. And it is in 2006 we really tried to address this issue of persons who are under threat or persons who are dead, and their evidence need to be brought into a trial. But I go back to 2006, Madam President, to really get to my colleague, Senator Mark, and his contribution in this debate. And if I go back to his contribution in 2007 to make the point on Tuesday, February 6, 2007, and I quote, Senator Mark saying, "I've been in the Parliament for a number of years and in the Honourable Senate for over 17 years, and the bill is one of the most dangerous pieces of legislation I've ever seen during my 17 years in the Parliament." And Madam President, that is what is in 2007. And 14 years after, we come and we hear the same thing, because in that contribution, Senator Mark talked about the usurpation of fundamental rights, trespass into the functions of the DPP, the AG giving himself a power to deal with criminal matters. There are pages and pages of interventions from both sides during this contribution. He talked about the far-reaching nature of the legislation, his newest reference, the Law Association not being consulted, the Criminal Bar Association not being consulted, and more and more pages of interventions and back and forth. You see, it is easy. You have the stature of Senator Mark, and he's now in his 31st year in this Parliament, stature, and you make these broad, sweeping, and baseless statements and accusations, that there are members of the public who will really believe this. But when you look at that, has been the pattern, and it has been the pattern of the opposition in dealing with this issue of evidence and the amendments to the evidence bill. If you go back, Evidence Act, if you go through the 4 or 5 key periods, especially under the PNM, the 4 or 5 key periods when we've attempted to address this issue of video recording, audio recording, and the bringing into statute what already exists in police procedures and in practice, we have always encountered this resistance
Minister,
from our colleagues in the
you
opposition.
have 5 more minutes.
And you know, it's funny that in all Senator Mark's contributions on the various evidence amendment legislation, that is the one in 2006, the one in 2009, the one in 2010, and every one, he was followed on every occasion by then Senator, Independent Senator Dana Sitahal, Senior Counsel, who is no longer with us, on every occasion. And it was almost like it was divine that he would be followed. And for example, in 2007, it is Senator Sitahal who followed Senator Mark and says, and I quote, "I think this is a good piece of legislation. This is something that Parliament must pass because it will protect the elimination of witnesses." After his contribution in 2009 on the amendment, it is Senator Sitahal who came after, and she said, and I quote, "On previous inconsistent statements, I support the provision. I think it is desirable given the current reality we live in." She also said in relation to the entire bill, I quote, "I think that this bill is necessary for effective prosecution in this country at this time." And I've done that, Madam President, to demonstrate that Senator Mark comes to this Parliament with a format. And the format is to open with allegations that the government is stripping citizens' rights. He follows with lack of consultation. He then suggests some names who should have been consulted. He repeats about the infringement of rights. He talks about inadequate notice to the government. He talks about contempt of the government. And then he goes into his usual rant about this is draconian, dangerous, far-reaching. It's sledgehammer to kill a fly. But that is just care tactics, because he does not wish, and the opposition does not wish to descend into the facts and to the truth. And in the truth of this matter, on every occasion, except that moment in 2010, when you came into government and within a few weeks, July 2010, you brought PNM legislation that had been passed in one house but lapsed. You brought that back. And it is the only time that you have been on record as supporting amendments to the Evidence Act, particularly those relating to the use of technology. So whatever you come here to try to hoodwink the country, your record does not support that. And as I close, Madam President, I want to say the Select Committee did some excellent work. I had the opportunity to chair the committee. Senator Vieira was also a member of the committee, Senator De Freitas, Senator Saddam Hussein, and Senator Donna Cox. And we were able to, in 2 meetings, meet and have the appropriate consultations. I want to say, Madam President, when the report was laid at Appendix 5, we had a consolidated version of the bill, which was the bill that was laid in the Parliament, and the bill that, through the work of the Select Committee, we recommended amendments. And there were 83 recommendations made by the Select Committee. The consolidated version at Appendix 4 shows the 83, and I'm very pleased to say, Madam President, that of the 83 proposed by the Select Committee and included in this draft, I believe 82, Senator Vieira, have found their way into the version that is before us, and I could be wrong, but at 12D, the amendment to 12D, where the committee suggested the insertion of the word other, I don't see it in this version, so the AG will look for it at that time when we get to that. But this work of the Select Committee appointed has found its way into the version of the bill that is before us. And Madam President, I fully support, and I know we have a lot of support in this country for legislation like this that deals with criminals in this country.
Senator Roberts.
Madam President, and thank you to the Honorable Minister of Agriculture for being the witness, the best witness against the PNM, to show that Senator Mark has been here 31 years, and every time the PNM is in government, he has given us evidence that Senator Mark has maintained a consistent analysis of the PNM's inappropriate manner of legislating and trying to attack criminal elements. What Senator of the Minister of Agriculture has stated shows that no matter what, the faces may change in the PNM, but the PNM remains the same for decades, coming to trample on the rights and abuse the Constitution of Trinidad and Tobago, as we are here again today, so to do. This is a critical debate, yet I don't see the zeal from honorable senators to debate. In fact, I'm shocked that I'm here so early. I plan to talk maybe at 7 o'clock. But there is a reason for that. And I am also part of it here in the Senate. I look around and I see lawyers and doctors, PhDs and professors. I see business people. I see all sorts of intelligent people. But I don't see the people who will be mostly impacted by this bill. I don't see the people who, if you take a little jaunt, a little walk down the street by the magistrate court, I don't see those people. So I don't think that we are getting a representation of those who may not have lawyers on speed dial. I too, I have lawyers on speed dial, father, brother, sister, son, everybody. But the people who are going to be affected by this most important bill are not represented here in the upper house. We are in the upper house as we've described, and we have certain abilities and certain opportunities that other citizens may not. So we need to spend and spare thought for them, because it's their lives that will be impacted by this bill. The Senator, the Honorable Renuka Sagram-Sim Sukral, last week said in a powerful, passionate, and I dare say loud contribution, I think she was louder than me, but she was brilliant. But she said, you need this bill to give the police teeth. But unfortunately, in Trinidad and Tobago, many police teeth are rotten, and them need dentures. The Constitution is the toothpaste, the dental floss, and the mouthwash to protect the citizens from the decay. Yet I come here and I hold 2 bills in my hand, one from 2019 brought by the very PNM, and this one here today, 2020. But the explanatory note in 2019 said this bill seeks to amend the Evidence Act, Chapter 702, to provide for the use of different identification procedures, interviews, and oral admissions, special measures, the taking of evidence by video link and witness anonymity orders. The bill would be inconsistent with Section 4 and 5 of the Constitution and is therefore required to be passed by a special majority of 3/5 of the member of each house. But then I come here a year later, and the same Attorney General in the same government bringing basically the same bill with even more draconian measures to impact the rights of citizens. That is eliminated. Then we begin in 2020 the Evidence Amendment Bill. The bill seeks to amend the Evidence Act, Chapter 702, to provide for the use of different identification procedures, etc., but simply eliminates the constitutional majority. And we come here to debate this. And my honorable colleague, the Minister of Agriculture, speaks en passant that we are just to make laws up in the sky, in the cloud of the upper house, but not worry about how it impacts people down there. That's the problem with the PNM, because you only worry about what you have to do and what affects you. We have to worry about all the citizens out there. George Jelinek, one of the greatest constitutional experts, wrote the essence of this Constitution. And this Constitution, Minister of Agriculture, while you're eating your local doubles, you should read it and study it. Then you will make more impassioned contributions that I could listen to. He said, the legal precepts are incapable of actually mastering the distribution of power within the state. In Trinidad and Tobago, we are seeing a massacre of the distribution of power. We are seeing the haves going higher and the have-nots going lower. We are seeing those in business rising and enjoying while others are suffering. And we come here today to widen the gap once again. He said the actual political forces move according to their own laws, which operate independent of any legal form. We'll get into more detail with that. Thirdly, he said the problem between it's the ought and the is. The ought is the Constitution, the basis, the law. We ought to be here making laws to deal with the criminal element properly while respecting everyone's constitutional right. One is innocent until proven guilty, and you cannot just create shortcuts because the job is difficult. You may put an innocent human being in jail because you need a shortcut. Shortcut is for traffic, not for laws. In 2021, under the PNM, the ought is a long-forgotten dream, and the is incompetence, dictatorship, disdain, and very dangerous. And according to the President of the Republic of Trinidad and Tobago, and I quote, dotish, the Constitution is the legal order of a state, or the life through which the state has the reality. This Constitution, which some of us seem to just discard, throw away, this is the supreme law of our land, and everything we do here must uphold this. But we just eliminate it and come here with 2 cases, same argument all the time, and eliminating rights of citizens. Yet today, once again, we enter the hallowed halls of the Senate, created and maintained by the Constitution, to continue the diabolical policy of this PNM government to desecrate, demean, and devour the very essence of that which makes us who we are. Number one, the legal precepts are incapable of actually mastering the distribution of power within the state. What does this mean? In this evidence bill, for example, we look at the entire essence of what they're doing, and we ask the question, what has prompted these measures? Is there a zeal to throw out tried and tested legislative safeguards for an attempt at optics and microwave justice? Why are we taking shortcuts? The tried and tested court judiciary system is there to protect citizens, to make sure and ensure that those who are guilty are punished. Our Constitution, in the preamble, Section B states, and let me read it because we are here making laws and like we forget it. B, respect the principles of social justice and therefore believe that the operation of the economic system should result in the material resources of the community being so distributed as to subserve the common good, that there should be adequate means of livelihood for all, that labor should not be exploited, Roger, or forced by economic necessity to operate.
Senator Roberts, you are reading a lot, but now you're getting irrelevant. You're not linking what you're reading to what is before us. So I'm going to ask you, please, to try and be a little more relevant to the bill at hand.
Madam President, I cannot say that my Constitution of the Republic would ever be irrelevant, but I am saying...
Senator Roberts, please, just take my advice and move on.
Thank you for your advice, your timely advice, Madam President. The evidence bill is here and is creating a divide between the haves and the have-nots, and it's ironic that a bunch of haves in the upper house are making laws for the have-nots. There's a difference in Trinidad and Tobago between zessers and wessers, how the law is applied. We see that daily. We see recusal twins getting rentals, recusing themselves and their families receiving millions and billions.
Senator Roberts, please. You're being completely irrelevant to the matter at hand. Please confine yourself to the remit of the bill.
Thank you, Madam President. Let me get back to the bill. In this bill, the evidence bill, we see that the proponents of this bill must be careful, very careful, that they're not hoisted by their own petard. You do not pass fast and convenient law because you think you are in power. You must pass law that can withstand scrutiny of generations, can withstand the imposition of menaces in office. We have been provided with no meaningful suggestion or rationale as to why the wholesale changes have been made. There is tinkering with the justice system at the behest of the Attorney General, an Attorney General who holds political office and whose political fortune lies therein. Yet we see in Section 12AA of this bill, for example, a witness anonymity order. This provided that where there are reasonable grounds to believe that the identity of a witness should be concealed from an accused person and the public as to protect the witness, any of the relatives or any person, the court may grant a witness anonymity order. Such a provision in this country,
Madam President, 46.1, please. I think he's reading from the wrong bill.
Senator Roberts, I think you need to refer to the clause because I too am having a little difficulty understanding which part of the bill you're dealing with.
I'm comparing the 2019 bill with the 2020 bill at Section 12A, but it's all right, I'll move on. The problem with this bill is that the ought and the is are separate, and that this bill is a shortcut to getting convictions or getting people to be arrested, indicted, charged, and convicted. Shortcuts have dangers, and citizens will suffer if we do not carefully analyze some of these laws. This government is suffering from a low detection rate and needs to make political moves to say that they are attacking crime. They have already stated here in this Senate that they have attacked crime under COVID-19 lockdown for 11 months. They brought the anti-gang bill, and it had failed dramatically. We saw no increase in convictions, but we saw a diminution of the rights of citizens. This government is a government of shortcuts. It was too difficult to test For example, in COVID-19, to test and contact trace, they took shortcuts without testing. Now we come here to bring legislation that brings shortcuts in a critical area of the judiciary. In Section 12N1, the identification in a public place, for example, under this section may be conducted without the consent of the suspect, where the identification procedure under this section is to be done without the consent or cooperation of the suspect. The identification officer shall ensure the procedure is carried out in the presence of the justice of the peace. The conduct of an identification procedure under this section without the consent of the suspect may only be conducted where A, the suspect is not in custody, or B, the suspect has refused to give his consent to the conduct of a procedure under Section 12M, or impossible or impractical to obtain the consent. In a practical sense in Trinidad and Tobago, how will this be done in public without the suspect knowing some justice of the peace is required to be present? This seems farcical and very dangerous. Have the powers that be considered this in a practical fashion as to how this will be done. Or the cynic will say, once they check the boxes of the requirements, the suspect could be identified in public with him or her knowing. One reads the papers with many confessions having been thrown out of the court, despite confession being supposedly witnessed by a justice of the peace. This is very critical to evidence. Just coming here last week, for example, I was speaking to a police officer and having a full conversation. And he said, but Senator, what are you doing here? We got notice that you would not be here. Then I realized he thought I was Senator Naked. This is a very serious situation with identification. Today, coming into the Senate, I walked in. I did not go to get my temperature. I came back to a police officer to say, please check my temperature. She said, but I checked your temperature. You were certain.
Senator Roberts, you have 5 more minutes.
She was certain that she had checked my temperature. I said, no, ma'am, check it for me again, please. Now, she did not do that with malice, but witnesses are sometimes mistaken, and by making shortcuts, bringing a bill here that does not allow for the rights of citizens, especially under cross-examination, or to have their attorneys present, and settles for justice of this peace, or video recordings that cannot be checked, is very dangerous. Witnesses do not have to be malicious. They could be mistaken, like today, coming in here. I recall a case, a very serious case in Trinidad and Tobago, where 2 PNM ministers were accused of doing wrong. Had this bill been in place back then, they may have been in another place. But under cross-examination, when evidence was given that somebody was collecting money by Smokey and Bunty, $13,000 and so on, when the witness went into court, the lawyer under cross-examination was able to prove that one of the ministers, PNM ministers, was not even in the country. In fact, was in Nigeria at the said time that the witness said he had given him certain amounts of money. And that cross-examination freed an innocent PNM politician and another one who is here today in the Senate because of the laws of natural justice, which this bill here is trying to eliminate. If this bill was the law back then,
Senator Roberts, you have 3 more minutes. Can I ask you, please, to lower your voice? Okay?
I thought I was trying to match Senator Renuka Sagram Singh, but I'm sorry, I'll talk short.
Senator Roberts. Yes, ma'am. Senator Roberts. Senator Roberts. Yeah. You have 3 more minutes. No, Senator Roberts, I'm sorry, your time is up. Attorney General.
Thank you, Madam President, for this opportunity. Thank you, Madam President, for the opportunity to bring conclusion to this debate. May I thank honourable senators for their contributions on the previous occasion of this debate and also on today's hearing as well. Madam President, the submissions have gone from the very useful to the somewhat challenged. I have to say that I actually thoroughly enjoyed the level of preparation brought by Senator Naked this afternoon on the opposition bench. I was genuinely taken aback by the level of detail and case law that went into that presentation. Congratulations, Honourable Senator. I certainly very much appreciate, if I could be so bold to single out Senator Welch today for having taken time to crystallize his submissions in material which has been circulated already. The government certainly intends on proposing considerations for amendment to the legislation before us. Certainly, a lot of this has come out of the public consultation, the Special Select Committee, the further opportunity for consultation which the Law Association itself requested back in December 2020, and then also as a result of the several days of debate that we've had. I must apologize. I had just sat with the technical staff to ask them to reduce some of our suggestions into writing. I thought that we had a little bit more debate left in us this afternoon, so we may be just a little bit late. Hopefully by the time I'm finished in this wrap-up, we can have those circulated. Madam President, there are a few general issues that I can refer to immediately, and the general issues start off with the familiar chorus of the opposition that the law requires a 3/5 majority. Indeed, Senator Naked referred to previous laws where there had been changes from bills initially introduced as special majority bills, then modified, and then reduced to simple majority. Permit me to say, for the record, that the bill that was presented in the work of the last Parliament that came before the Special Select Committee was indeed a 3/5 majority bill, and that is specifically so as it proposed something which I'm a very strong advocate of, something which all of the persons attending before the special committee agreed should be part of the bill, and that is the provisions of anonymous witness evidence measures. Unfortunately, the opposition does not support that provision. For us in the government, we believe that that is a nuclear device to be deployed, and we say that that is most respectfully so, not only because the rest of the Commonwealth has agreed with that position, including the European Court of Human Rights. Everywhere else in the world believes that witnesses should be given a fighting chance. And therefore, I want to put it squarely onto the record. The reason for the special majority considerations was squarely pegged to the witness anonymity provisions. Having removed those provisions from the legislation, from the bill that was in the last Parliament, we therefore had the opportunity to remove the special majority. And let me put it quite simply. You don't have to introduce a special majority unless there is a requirement to do it. The Constitution says if you're going to abrogate Section 4 or Section 5 rights in such a fashion as to affect what we consider within the meaning of Section 13 of the Constitution to be a society that respects democracy such as ours does, then you have to consider that. Now, Senator Lachmedial put it quite comically and quite correctly onto the record. I wonder which of the two cases we'd go for, whether we're looking at Northern Construction or Surat. And it's just quite simply the fact that those are the cases that are of record. And of note, Surat in the case of the Privy Council's determination in particular by Baroness Hale, and therefore there's nothing to stop the fact that when one looks at proportionality, you have to look to see whether the intrusion is of a type such that you're affecting the law within the meaning of the Constitution. The Barry Francis decision is, of course, of important note. Chief Justice Archie, in the minority in that particular decision, gave a very interesting look at the law of proportionality, but unfortunately that's a minority view. And that minority view has not been accepted by the Privy Council, and therefore the law stands as it does, that there is a concept of due process and fairness that is required. This legislation, when you look at it in the round, is squarely designed with due process and with fair trial provisions in mind. What we are proposing in the legislation is effectively to take the embodiment of our standing orders, of the judge's rules, of the common law requirements, and to codify them into the primary law. Why do we wish to do that? There was a genuine question put both by Senator Welch and Senator Lodge Medial saying, well, look, normally the government is an advocate of framework legislation. Normally governments are advocates of staying away from prescriptive law. But on this occasion, let me put onto the record, it was in 2013 that the Ministry of Justice under the opposition, then government, went to work at looking at the evidence laws. And if I'm not mistaken, 4 ministers of justice later and 7 ministers of national security, including junior ministers in that government, went into this exercise of a policy of taking the prescriptive work and putting it into parent law. It would have been reckless of a government coming into the equation not to take a look of provisions. We certainly agree that on this occasion the prescriptive approach is to be applied. And why do we say that? We are insistent on doing 2 things. One, carrying the IT improvements as they have been brought to life in the current judicial climate into effect in law. That's one. And secondly, and very importantly, to create a standard for the Trinidad and Tobago Police Service to operate under. It is not acceptable that there are varying degrees. The law is capable of being templated and formatted, and in those circumstances, we believe it imperative that we apply the use of technology into our law, and secondly, the templating to protect the rights of the accused. Now, I want to say that this comes in the context of a process of reform. We stand in Trinidad and Tobago today, and I can tell you that the interview room project that we have deployed across the police stations demonstrate that we have 19 new interview rooms. Piarco, Arima, Maruga, Maloney, Kumuto, Oropuch, Maracas, St. Joseph, Belmont, Labre, Brasso, Sangre Grande, the ACIB unit, Riverside Plaza ×3, Gasparillo, the Financial Investigation Branch, Maraval, Aruca. We have record devices to Special Branch. We have Shervan Road. And, Madam President, that is now being expanded into the Police Complaints Authority and into the courts. We are now in a world where we have already applied the benefit of technology in virtual appearances, in our rules of court, in our FTR as it's referred to in the courts, where the magistracy is now with audio and video recording equipment for the first time in the history of Trinidad and Tobago. When I became Attorney General in 2015, I can tell you, the magistracy was on a manual record system. We were looking at no full judicial immunity for magistrates. We were looking at 12 divisions of court. There were no virtual appearances. There were no criminal proceedings rules, no amended family proceedings rules, no children's rules, no electronic filing mechanisms. Today we stand with upward of 25 masters now about to come to life, with a criminal division, a family division. We have a probate division. We're coming with a small claims division. And therefore, we have taken justice really into a different form of management. You would have heard me say time and again, plant and machinery, people, processes, and then the law. And that's why I can say with certainty, as the build-out of the civil court at the waterfront is fast nearing conclusion, that with the addition of 129 new courtrooms, not including the Princestown courts, which are due to be opened shortly, not including the rapid pace of the San Fernando Magistrates Court, which is faster pace now, not including the family court in San Fernando, that we are finally headed into the realm where technology meets with the reality. Madam President, a feature of the debate across us was the caution, quite correctly, that we have resources. Those resources are now a matter of record. With over 1,000 jobs created in the judiciary, with specialist provisions having been added to the Trinidad and Tobago Police Service cybercrime, interview stations, records. We are in a different place today, Madam Speaker, Madam President. Now, I heard somebody mention, two honorable senators mentioned, whether this law was ad hominem and whether this law was designed to take care of certain matters involving white-collar allegations, etc. And I'd like to put that to bed. This matter does not conclude in making a submission such as that. This is not directed at any one matter in Trinidad and Tobago. Is it lost upon us, Madam President, that there are serious matters of complex fraud that are now going on 20 years in the courts? Or that there are matters 11 years and hundreds of millions of dollars, if not close to $1 billion in expenses in white-collar and complicated matters? We cannot be watching a system such as Section 14B of the Evidence Act, which this bill amends, or Section 40 of the Evidence Act, which this bill amends, knowing that the admissibility by paper evidence will come upon us when we're looking at hundreds of thousands of documents in complex fashion. We have to be anticipatory of the rapidity of justice and to watch the cultural change in our society. Madam Speaker, Madam President, have we noticed, by way of application of resources, that because of the amendments to the law in the simple matter of decriminalization of motor vehicle and traffic offenses, we are now watching Trinidad and Tobago rush to check tint on a car? That was a thing that didn't happen in this country. Obeying the speed limit, making sure you don't offend for demerit points. People now have a level of conscious reflection because of improvements in the law. And this bill is certainly no exception to that factor. Madam President, I'd like to thank the members of the Law Association, the subcommittee that submitted comments to us most recently, and in particular to the work of the honorable senators in this House. And I'd like to say that we certainly agree that we need some clarification. We do agree that Section 12, the new proposed Section 12A, we propose that that in fact be amended. We're looking at amendments being proposed on our side to join with those proposed by Senator Welch to propose Section 12A as in alpha, subsections 1, subsections 4 and B, because the truth is that you can in fact move away from the investigating officer and the identification officer and to apply the general rules so that you are on first description met with somebody who has the capacity to do it as opposed to a defined individual. We agree with Senator Welch's submissions in that regard. We propose that we, in light of those recommendations, remove doubt in further sections of proposed Section 12A by amending the cross-references in subsections 5 and 6. We propose, Madam President, that with respect to proposed Section 12B, subsection 3, that again, with the use of an officer as opposed to the officer, that there's a need for amending, again taking up Senator Welch's recommendations, which accord with the government's proposals as well. We believe, Madam President, that proposed Section 12C, subsections 2, 5, C, and D also be amended. We believe that there is an improvement to be had, again, in the flexibility of the officer's approach, not as defined individual, and that we improve the references to witness to be what we intended, which is eyewitness as opposed to witness in general. We also believe that there is merit in Senator Welch's consideration for sections 12C, subsections 4 and 5, and we propose to address that in committee stage. Madam President, one of the underwriting points, one of the backing elements of the law as it comes to the use of video technology, that's a core principal point which the stakeholders in the submissions that we received, and there were significant submissions received. We believe that the use of video evidence is something that we have to encourage. We are very mindful of the fact that we can only proclaim this law if the technology is there side by side for utilization. There will be training, there will be practice directions. We do have the regulations in circulation, draft regulations, for the benefit of honorable senators. It's very rare that governments come with draft regulations even before they're finished. We're waiting for the Commissioner of Police and for the Director of Public Prosecutions to come back to us. We've been waiting since November of last year, but we're giving a reasonable opportunity for consultation on those regulations. We do believe in that context then that 12E, as in echo, really ought to be with a priority for video evidence. Senator Welch, perhaps we'll discuss this in better detail at the committee stage with his proposals, the Honourable Senator's proposals, that we go to writing first and then have the other points. I think that the philosophy behind that can be ventilated in committee stage so we understand a little bit better the submissions. Madam President, we also believe in section 12G, as in golf, that the may for shall should be changed, that we shall use a justice of the peace when the rights of the accused are going to be potentially affected. That's a very welcomed amendment coming from Senator Welch, which we propose be added into the law. We believe that amendments ought to be factored to sections 12R, as in Romeo, subsection 2, 12X, subsection 1, and 12Y, subsection 1. We have to discuss, and I'd welcome views at committee stage, this concept of one suspect versus two. We went with the UK approach of two suspects at the same time, which also met with Standing Order 29 in our police structures. So we went with what we consider to be the existing law. Senator Welch has made a proposal that we only do one witness, one suspect at a time. And I think that that's something we can have a look at. We preferred to keep with the practice of Standing Order 29 in our structure, which accords with the UK structure as well. But perhaps we can understand a little bit better the concerns that Honourable Senator Welch had. Madam President, I think that there's an improvement to be made as proposed by Senator Welch with respect to section 12K, as in kilo, with the utilization of one-way mirror as opposed to screen. It was reflected in subsection 8 there, and therefore we can harmonize that by changing the word screen to one-way mirror. The concept of proposed amendments to section 12Q, subsections 1, 2, and 6. Again, this is a philosophy and a policy that we'd have to touch at committee stage when we're looking at the concept of putting it in writing per se. Madam President, the recommendation came from Senator Welch that we delete the register of interviews. That, for the government, is a policy point that we consider to be very fundamental to the legislation. We believe that there must be a register of interviews because far too often justice is thrown away, so to speak, on the basis that you can't find a station diary or a book, or there's some confusion in respect of the evidence that is given. We think that a harmonized register, much like we have done for the domestic violence register, the reporting of domestic violence matters, what we're dealing now with sexual harassment, which will come shortly, and children's matters, we propose that there is a unified system so that when you wish to have access from remote locations, that the database is properly matched. That goes in line with the amendments that we have brought into the judiciary and now in the Director of Public Prosecution's office, as well as the Public Defender's Division. Permit me to stick a pin on that point. I've heard honourable members question whether law will work. And I've heard honourable members on the opposition bench ask that question, or indeed cast some doubt, if not pour scorn, upon the ability to cause amendments and to see the effects of it. I'd like to remind, at every stage that the government has brought amendments in the last Parliament and this, we were met with disbelief on members, on the bench of members opposite in the opposition benches. And I'd like to say, when you look at the success that we have found as a country in judge-only trials, the success in plea bargaining, the 97% addressing of the motor vehicle and road traffic amendments. Let me put that into context. When, as a country, your annual magistrates load is 146,000 cases a year, and a government is able to stand up and say, listen, as a result of amendments to the law, 104,000 cases a year have been removed out of 146,000 cases. That is no small feat, Madam President. When you say to a country that as a result of decriminalizing marijuana, 8,500 cases have disappeared from the 146,000, that is no small feat. When you're able to say that with the abolition of preliminary inquiries, which is imminent, that you will be able to manage 26,000 cases per year in a different fashion, that is no small feat. And therefore, the use of technology underwritten in the amendments before us, in the identification route, in the use of consistent standards with fair trial in mind, where a judge always has the discretion as to admissibility of evidence, that's the ultimate sanction. It isn't that the law needed to criminalize a failure to observe the standards set out in this bill. The risk comes to the inconsistency removing the admissibility of the evidence, and therefore the preservation of fair trial and due process maintains the paramount standards required to protect the rights of the individual. Hence the submission that this law is entirely proportional, is entirely in the best interests of the citizens of Trinidad and Tobago. Madam President, we certainly do believe that an improvement to Section 12U as proposed by Senator Welch should be entertained, and that you shall be given statements. When we look to 12X, again, the concept of practicability, we agree with Senator Welch's amendments proposed there. But when we get to Section 12Y, again, there's a philosophical position that perhaps we ought to consider at committee stage. But 12Y is where we treat with what the government considers to be a very fundamental concept of video recording and admissibility. We agree that the word shall can perhaps be viewed to be an undue interference in the separation of powers principle, and therefore the word shall ought to be changed to may, and certainly we agree with that submission so that we leave it to the discretion of the judicial officer as to admissibility of evidence. Madam President, we're headed to a better place as a country. Whether people in this country believe it or not, at the end of the day, I am genuinely warmed to see throngs of people worried if their tint is too dark, to see throngs of people worried that they may be caught for a demerit point system, because this is back to what was once viewed to be the broken window theory, or the putting justice into place. Madam President, the CCTV evidence and the admissibility of it, which this law provides, is directly tied into significant amendments to our country. What do I mean? The deploying and implementation of a program of something called Eyes Everywhere. Cameras that capture facial recognition, number plate recognition, RF tag IDs on license plates. That is where you get to police your roads, to have people comply with the law. And therefore, taking the concept of CCTV evidence is opposite to witness protection. We all remember that terrible case of CCTV evidence of a car rolling over somebody who had had an epileptic fit. Twice, 2 cars rolled over. If you can discover the evidence and it is admissible, it avoids people being worried as to stepping forward to give evidence. Left up to me today, the work of the Special Select Committee, which approved anonymous witness orders to give witnesses a fighting chance, would see the light of day. Unfortunately, the UNC, led by Mrs. Prasad Bisesa, does not agree with that. They are entitled to that position. I cannot condemn them for their point of view, other than to say I think that that is keeping back our country from its best effort and its best intent. But that is what democracy is about. This government does not have a special majority in the House of Representatives, and therefore we cannot pass that law, and therefore we must adjust our cloth to make the approach that we do. 5 minutes? Much obliged, ma'am. So, Madam President, I genuinely commend honourable members for for the level of preparation that they have engaged in approaching this debate. I thank you for the submissions that have been received. I wish to say to the Special Select Committee, thank you. The committee was chaired by Senator Rambarat, who gave an exceptional delivery today in recounting the history of this law and how it is we have come to this point. The vast majority of work that we have taken on board in this new bill comes from the work of the Special Select Committee. I would like to thank the drafters at the Attorney General's office, Ms. Nirana Parsan, Ms. Veronica Sahadio, and the CPC for the work that was conducted, the CPC's team for the work that was conducted in supporting the work of the Special Select Committee. As Attorney General, I can say, Madam President, we've spent years producing this work. It did not come in any form or fashion other than by a significant amount of scrutiny, ample room for digestion, comment, review, amendment, and then tabling. Madam President, we propose to circulate amendments for consideration at committee stage, and I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Evidence Act, Chapter 702, be read a second time. Those in favour say aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Evidence Act, Chapter 702.
Attorney General.
President, in accordance with Standing Order 66-1, I beg to move that a bill entitled An Act to Amend the Evidence Act, Chapter 702, be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that a bill entitled An Act to Amend the Evidence Act, Chapter 702, be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Honourable Senators, I know that we are awaiting the amendments to be circulated on behalf of the Attorney General. So I propose at this stage to suspend the deliberations of the committee for... We will return at 10 minutes past 5. So we
that are being proposed. I find it a bit, I'll need your guidance. We have all completed our contributions, and the Attorney General is now going to circulate amendments. And I would like to get your ruling on this matter, because would we now be given an opportunity in committee, given the nature of these amendments, as to whether we are going to get extra time to debate these things? Because I don't know what these amendments are.
Senator Mark, this is not the first time that this has been done in committee. And also, when we have amendments circulated at the committee stage, there is vigorous interrogation of the issues, and leeway is given for persons to raise issues that arise from the amendments. Honourable Senators, we will resume the deliberations of the committee at
5:30?
At 10 past 5. So this committee suspended.